Again, good morning, good afternoon, everyone. Welcome to the first session of the panel discussion today on the topic of the rising of generative AI and the impact on the IP landscape. My name is Kevin Fan again from Taiwan's law firm Tsai Lee and Chang. Before going to the main topic, I would like to firstly make a brief introduction of our distinguished panel members in the alphabetic order of their last names. The first speaker we have is Dr. Magali Cantardi. She's IP lawyer and is also founder of her own law firm, Cantardi IP Law. She is an Italian qualified lawyer with focus on both of legal practice and research in IP. Before funding her own firm, she worked as an IP attorney in the top-tier international law firms in both Germany and Italy. And she served in the International Affairs and Legal Department of the EPO, and also she had work experience at the Board of Appeals of EU IPO. She has extensive legal educational background across different countries in Italy, Spain, Argentina, and France. She obtained her summa cum laude in her PhD degree in law with partial, at least, focus in AI, patents, medical devices from the University of Alicante. The second panelist we have is Dr. David Tirosh. He is an associate in the IP practice group at the S. Horowitz and Company, which is one of the Israel's leading and largest law firm, which has been placed in the top tiers of many international ranking guides. David specialized in IP litigation, consultancy, particulars in all kinds of IP, you name it, patent, copyright, trademark, trade secret, and other IP-related disputes. He represented major international and domestic companies in various industries. He has a strong focus on life science, though, and also pharmaceutical industry. And he's also the active member of the AIPPI Pharma Committee. The third speaker we have is Dr. Dan Zhou. She is a patent attorney. She joined the Patent and Trademark Law offices of the CCPIT, which stands for China Council for the Promotion of International Trade, after she graduated from the Tsinghua University in 2015. She provides all kinds of IP services, including patent prosecution, patent validation, and litigation. And she has given the keynote speeches on AI-related patent prosecution at many industry conferences and seminars many times. She's a member of the Standard and Patent Standing Committee of the AIPPI. So go back to the main topic that we have. Well, we're talking about AI, and we go back to the history of the human industry developments. We have been always been trying to more ways to improvements and technical advancements to try to make our lives more productive or economically more efficient, so our lives can be more easier. So go back to 18th century, we started in the age what we call the industrial revolution. Humans started to know the machines, and 100 years later, we started to use electrical engineering, the energy to power our machines. And starting a couple of decades ago, we started to use computers, and how computers go into each household and each of individuals. Recently, they started what the age they call it Industrial 4.0, the era of information explosions, and the efficient computation by smart machines. So that comes with the term of artificial intelligence. According to the Wikipedia, AI is the ability to learn and to reason and to generalize and to infer meanings that are demonstrated by machines. In other words, its core concepts to allow the machine not to only to gather information, but to summarize in order to guide or to pinpoint a particular solution. But seriously, what really is about AI? It still sounds very vague. And what is the application and possible boundary of it? And what is its use in the interactions in the field of law or even intellectual property? So as we discuss internally before prepare for this panel discussions. David has some background knowledge sharing about that based on his research. So now I'm going to hand it over to David.
So thank you, Kevin, for the introduction, and thank you to Debbie and Samantha for inviting me here to discuss the rise of generative AI systems and their impact on the IP landscape. So what is generative AI, and why should it even bother us as IP practitioners? Well, generative AI systems are a type of artificial intelligence technology that uses machine learning. But what is so unique about generative AI systems in comparison to the traditional learning systems is that they go a step further. This is because they specifically deal with generating new content based on their understanding of what they've learned from the training data, and not only predicting or performing tasks based on it. These systems can create extremely impressive content, including human-like text, realistic images, videos, music, and computer code, typically in response to user-based prompts. In generating text, perhaps the most recognized generative AI machine is ChatGPT-3. It is a language model developed by OpenAI, which was released for the general public in November 2022, capable of generating human-like responses to prompts or questions, and estimated to have been trained on around 45 terabytes of text data. Some generative AI systems are designed to produce imagery. The faces you see on this slide belong to people who have never existed. They're synthetic and were generated by NVIDIA's StyleGAN generative AI system. Another known generative AI model is Midjourney. Believe it or not, the creator of this artistic work generated by Midjourney even won an art competition in Colorado, which, as one can imagine, sparked a strong negative reaction from artists. These are only non-exhaustive examples. Applications of generative AI systems are broad and can produce not only text or images, but also computer code, videos, music, and more. So now that we have a general understanding of what generative AI systems are, let's return to the basic question we began with. Why should we, as IP practitioners, care about it? To answer this question, I suggest we start by mapping the relevant stakeholders and distinguish between the input and output of generative AI machines. Of course, there's the user. The user cares about the output. She signs into ChatGPT, Midjourney, or whatever generative AI system you'd prefer, and now she's contacting you as her IP lawyer. She asks you 3 questions relating to the output generated by her inputs. First, she wants to know whether these outputs are eligible for copyright protection. As they were generated by a machine, it's not an easy question to consider. When we studied copyright law, we were taught that one of the purposes of granting copyright protection to works is to incentivize authors to create works, not machines. The United States Copyright Office recently issued a statement of policy on this matter. It clarified that if a work's traditional elements of authorship, such as literary, artistic, or musical expression, were actually conceived and executed not by a human being, but rather by a machine, then it will not be registered as a copyrighted work. As example, if you instruct ChatGPT to write a poem on young AIPPI members in the style of William Shakespeare, ChatGPT will likely determine the expressive elements of its output, such as the rhyming pattern, the words in each line, and the structure of the text. Under these circumstances, such output will not be considered the product of human authorship and will thus not be registered as a copyrighted work. The second question your client may ask, assuming that the output is eligible for copyright protection, is whether she's the owner of the copyright. As these systems are, in the end, software, use of such software is governed by their terms of use, which usually indicate, although not in all cases and subject to other restrictions, that the user owns the right in the output. A third question which she may pose to you is whether others can prevent her from using the work, alleging that it infringes their copyright. Suppose that she prompted Midjourney to generate for her a photo of Prince's portrait in the style of Andy Warhol. As you can see, I've tried it myself, and as we recently learned, using this output could potentially be considered copyright infringement under certain circumstances. So please don't tell anyone about this slide. But what I would like to discuss are questions from the perspective of generative AI developers and copyright holders, and solely concerning the input. Unlike the user, who will typically care only about the output generated for her by the system, developers of generative AI systems and copyright holders will also care about the input of the system. Generative AI systems They're as good as the data they're trained on. They need enormous amounts of data to train on in order to be able to generate new content. And this data must be vast, diverse, representative, and relevant. This leads to an immediate clash from an IP perspective between copyright holders and developers of generative AI systems, as this data will almost certainly include copyrighted works. But how should the legal systems view the training of machine learning by developers using unauthorized copyrighted materials? This question, is no longer theoretical. Complaints and proposed class actions alleging copyright infringement by training generative AI systems on copyrighted works are already being litigated in various jurisdictions. I would like to shortly convey to you the Israeli perspective on this question. In Israel, the Ministry of Justice has rendered an opinion on the question of using copyrighted work for machine learning already in late 2022. Although it was rendered with respect to a specific governmental project, it nonetheless provides a broad analysis and is perceived by many IP practitioners in Israel as applying to the training of machine learning systems at large. The ministry initiated a roundtable discussion with relevant stakeholders, which included the submission of formal comments, including by Google Israel and associations composed of Israeli authors and creators. The opinion concludes that in most cases, using unauthorized copyrighted works for machine learning will constitute fair use, and in some cases will even fall within the permitting doctrines of incidental uses or transient copying. Now, as you can imagine, this opinion caused waves in the industry and drew strong criticism from artists and associations composed of Israeli authors and creators. In the short time I have, I will strive to quickly present to you with what I perceive to be the main takeaways in the opinion relevant for your IP practice. The opinion begins by noting that from a formal technical perspective, using copyrighted materials to create a database for machine learning will require reproducing the materials as well as storing them in the database, both of which constitute reproduction, an exclusive right conferred on the copyright owner on the strength of the Copyright Act. It also states that developers will often make changes and sometimes will even make deliberate manipulations for creating more than one variation of the work for the purpose of expanding the dataset and its diversity. Such changes may fall within the copyright owner's exclusive right to make derivative works. Theoretically, there is also the potential of infringement of the moral rights of the author in the training process. From an Israeli law standpoint, we're speaking about the right of attribution and the right of integrity. However, according to the opinion, in the case of machine learning systems, the lack of human audience voids both the interest of the author in receiving credit, as well as the concern that the dignity of the author will be impaired due to the modification of her work. The opinion mainly focused on the fair use doctrine. It starts by contending that creating the dataset and using it for machine learning is made for both self-learning as well as for research purposes. It falls within the realm of self-learning because the machine learns by itself and in somewhat similar fashion to how humans learn, by examples. And it apparently falls within the realm of research due to the analysis, selection, sorting, and characterization of data that is inherent to creating the dataset, as well as since the way machines learn is a subject for research in and of itself. The opinion continues by analyzing the 4 factors test of fair use. Regarding the purpose and character of the use, it was noted that the purpose of creating effective machine learning datasets is essential for ensuring effective, safe, and competitive machine learning systems, and thus constitutes a worthy cause, albeit sometimes commercial. As for the character of the use, it noted that a holistic examination shows the creation of the dataset is highly transformative due to the intensity of the contextual change of the use. It referred to autonomous driving systems and natural language processing systems, NLPs, as examples of highly transformative uses. Although they possess learning processes, which included digestion of copyrighted works in their entirety, ultimately, the use made by these systems differs totally from the original use of such works and is thus considered highly transformative. As for the nature of the copyrighted work, it concluded that the issue cannot be categorically addressed due to the endless possible applications of machine learning. And as for the quantitative and qualitative scope of use, it noted that the works are fully reproduced in the training process, but it's only due to the technical limitations inherent to the architecture of learning systems. Therefore, what would be deemed relevant to consider are the actual elements that were ultimately used. In cases where the learning model is mainly based on unprotected aspects of the work, such as facts, ideas, and syntactic structures, this factor should add further support to the finding of fair use. As for the impact of the use on the value of the work and its potential market, one of the main arguments for establishing fair use in this context is that the expansion of machines' access to works will not impair the existing markets of copyright owners, since those markets, according to the opinion, did not even exist in the first place. Now, this point garnered some criticism from the industry. Only 6 months have passed, and NVIDIA has already announced on the launch of its own image-generating AI system, which was trained on images licensed to it by Getty Images and others, and of its intention to pay royalties. The opinion also calls for exploring a new, fifth factor in the context of machine learning training, namely the diversity of the dataset. As noted in the opinion, where the dataset is more diverse, the finding of fair use will be more plausible. As a matter of fact, it has been established that most databases do indeed aspire for diversity, thereby pointing towards fair use. However, a dataset comprising exclusively of a specific photographer's works for the purpose of training the machine to mimic that photographer's style, that will not constitute fair use. To conclude, in most cases, it seems that, according to the opinion, using unauthorized copyrighted works for machine learning will constitute fair use. Due to the constraints of time, we were unable to review the other doctrines analyzed in the opinion. However, the bottom line is that such training may also be covered by the doctrine permitting incidental uses of copyrighted materials, and in the irregular case where the copyrighted materials are erased at the end of the system's training process by the doctrine of transient copying. Personally, my takeaway from this opinion is that the analysis of transformative use is overly generalized and does not necessarily apply to generative AI systems. The opinion does provide compelling examples of natural language process systems, NLPs, and of autonomous driving systems to make the point of highly transformative use. And these are really good examples to support this argument. I mean, when it comes to autonomous driving systems, they use films as training data largely because they offer a wide range of real-world scenarios and driving situations in order to improve their driving capabilities. These systems couldn't care less about the composition, lighting, and other creative decisions ordinarily made in the film creation process. Additionally, they do not use those films to create new films, and in any case, they have no intention of creating films that will compete with the copyrighted films on which they were trained on. These are therefore good examples when making the point of transformative use. However, when it comes to generative AI systems, at least the ones viewed by us at the beginning of my talk, they're completely different in that sense. I mean, take Midjourney, for example. It trains on images for the purpose of creating images. Its focus is on the creative aspects of the images it trains on, and it does compete in the same market in which the copyrighted images are sold. So I wonder, doesn't the case of generative AI systems such as Midjourney differ from the case of autonomous driving systems and NLPs, at least in the sense of the transformative use analysis? Personally, I think it at least calls for some thinking, and I suggest that when analyzing transformative use, we should consider the potential differences between traditional learning systems and generative AI systems. Thank you for listening, and back to you, Kevin.
Thank you, David. It's really, really interesting, really broadened my horizon. A lot of the point that you raised is really something I didn't have a chance to think of. So now I'm going to hand it over to Magali, because Magali, she has a lot of perspectives from the European side on this topic over AI and copyright and other rights, etc. I'm handing over to Magali.
Do you see the screen now?
Yes, it's good.
Perfect. So thank you very much, Kevin, Samantha, and Debbie for the kind introduction. And thank you very much, David, for sharing with us the Israeli perspective. Very interesting. Well, as Kevin introduced it, I'm going to provide the European perspective towards the similar issues. And to begin with, I wanted to start with some examples of how artificial intelligence has been used, let's say, in the creative or creation landscapes. For instance, in the music industry, on literature for writing poems, as you see in the example of on the left, in which the AI system had been trained, say, with poems created by human beings, and then had produced an output that is actually recognizable from the judges that were in the contest. Well, the one that you see in the middle is a very famous example in which the AI system has been used to produce, let's say, a painting that resembles, let's say, the work of the famous Dutch artist Rembrandt. And music, as I said, we have two examples here in which the creative process, let's say, is different. If in the folk RNN app that I'll encourage you, let's say, to use, basically the system, you just press the button and it produces, let's say, the music. Whereas in the second, the Davis card, it was a system that was used was trained with a whole repertoire of the Beatles, and a human person, let's say, had manually, let's say, selected the orchestration and the lyric. So going straight to the point, the 1 million question is, are these outputs protected by copyright? And when we look at as a starting point, we look at the Berne Convention, International Framework for Copyright. We know, let's say, that for recognizing copyright protection, we need on the one side a work, and that work has to be original. But the Berne Convention does not define originality. It's a matter of national law. And when you go, let's say, or when you come to the European Union, the requirement, let's say, of human authorship, it is suggested or derived, let's say, by the interpretation that the Court of Justice of the European Union has done of the concept of originality. We have a lot of cases, and especially since the InfoPact decision, in which the court had mentioned that a work can be protected by copyright if it is original, in the sense that it is the author own intellectual creation, which means that let's say, the threshold is not very high, but it has to let's say, show a personal free creative choice of the author that are indeed expressed in the work. So there must be, let's say, an author personal touch. And the particularity of this interpretation in Europe is that originality is said to be an autonomous concept, let's say, of the European Union. That means that national courts should follow, and it's quite, let's say, organized, harmonized, should follow the interpretation of the European Union Court. So that's why when you go to the national courts, it's very unlikely that you will find a different interpretation. As you there is no, as to the day, let's say, in Europe, there has not been any case that have where the courts have ruled directly on the protection of AI outputs, but we can mention, as you see in the slide, there is an indirect, let's say, suggestion from a recent ruling that was held by the Italian Supreme Court in this February 2023, and it relates to the use of this flower that you see in the slide, that is called digital artwork flower, and it was created, let's say, it was used in the Sanremo, which is the most famous Italian musical contest, and it was created, let's say, by an architect, but he had used a software that generated the shape, the details, and the color through this mathematical algorithm, which had reproduced, let's say, the form in different scale and different shapes. The word has been used allegedly, let's say, without the authorization within, as I said, the Sanremo festival. So of course the architect, let's say, he sued for a copyright infringement, and the defense raised, let's say, by the defendant was that this work was not original because the choices that the author had, or the choices expressed, let's say, in the author were just, let's say, to choose the algorithm and approve the result that was generated by the program. But as I said at the beginning, the court indirectly, let's say, touched upon the issue, because this defense was raised at the later stage of the proceedings, so that was dismissed. However, the court suggested that the fact that one uses a computer to create a work does not necessarily exclude the creation of an intellectual work that is eligible for copyright. So then suggesting that we should look into more in detail how this creative process took place. So if we don't have, or if the issue of the copyright is still to be defined, what about the related rights? Can we say that the output generated by AI can be protected by neighboring rights? So in the examples that I bring you in the slide on the left, it's a famous AI robot that is called Shannon, and he plays marimba music. He produces his own composition, and he's capable, let's say, to perform them. So when we look at the protection specifically on the performance produced, let's say, by these AI robots, looking again at the international framework and mainly at least at the national level of European law, when we look at the definition of performance, there is the implicit human being requirement. We talk about actors, singers, musicians, and dancers, and these are the persons who perform. But what about the opposite example, which is the one on the right? There you have a human orchestra that is playing AI music. So do we need an underlying protective work to talk about the performance of those, to talk about the related right over those human performance? Well, if we look again at the international framework and say member states have certain degree of discretion of whether to award or not related rights. In the European Union, the law does not require the performance of works, in the meaning of copyright, to grant rights to performers. But the issue is not very much harmonized, and there is no uniform approach across the European Union countries. So we will have countries such as Belgium that do not require the performance of work, or even Italy for granted relating rights, whereas other countries such as in France, they do. So the situation could lead to cases in which we have performance of AI generated product protected by related right in some countries, whereas in other not. So looking from a different perspective, the second question is, can the training of this AI infringe, as David said before? And we have been heard, let's say, increasingly authors across the globe, let's say, to denounce that AI systems have been trained by using their intellectual creation without their authorization. And in other jurisdictions, such as in the US, as mentioned before, the issue, let's say, had escalated, let's say, towards court. Well, in Italy, in Europe, and also in Italy, again, courts still have not decided, and say, on the matter. But we have, or we can mention, two important decisions or judgment of the European Court of Justice that could be relevant in this context. The first of them is the already mentioned InfoPack case, in which it was held, let's say, that even 11 words could express, let's say, the author on intellectual creation. So again, as you see, the threshold is not very high. So this could suggest that even the unauthorized use of such 11 or these 11 words could amount to copyright infringement. And the second case is the Pelan case that it was related, let's say, to the sampling or the unauthorized use of a sample of a famous metal song. And in this case, the court considered that the unauthorized sample of even 2 seconds could infringe the rights of the producer if that sample taken was recognizable to the ear. So in the final output, it was recognizable. So this could suggest that even tiny portions used in the training for AI could amount to copyright infringement if they were to be recognized in the final output. A related question is, could the training of AI fall under the text and metadata mining exception? As you know, and differently what we heard before, in Europe, there is like a very specific list of exceptions and limitations. So we don't have fair use. And recently, the copyright reform had introduced 2 mandatory exceptions related to text and data mining. So that, and it has been discussed whether this exception could suffice, let's say, to cover, let's say, the situation of the use of protected material into the training. The main problem, let's say, that this exception has is, first of all, that the exception that is related to any commercial use can be overridden by contracts, so parties could exclude it, so amounting then to a copyright infringement. And also, it is very tiny in the meaning that it refers only to the reproduction. And even if there is quite harmonization, the transposition has not been so uniform across European member states. So I would say that the question that the solution is a gray area. And to conclude, when we look at the design, the same question, inside from the design perspective, well, the first is whether we can mention this AI as an designer. The same question has been raised in the context of patents, but and we know by the Davos decision that it's this situation, at least in Europe, is let's say the answer is negative. But in designs, we can let's say waive the designation of the designer. So the same issue will not arise. And very briefly to conclude, because of time constraints, sometimes, let's say, we don't have, when we use the design for the training of an AI, we don't have similar exceptions. So this production, when it produces, let's say, an output that is similar to other existing prior designs, could amount still to copyright infringement without the possibility of raising any exception. So thank you very much for your attention, and I will pass again to Kevin. Sorry for the
not a problem. Thank you, Magali. Wonderful. Now it's Dan, do you want to share with me, do you want to share with us about the Chinese perspective on the interaction between generative AI and copyright? And also, as we discussed during our preparation, that you have a lot of it shared about the patent versus AI. So
sure.
now,
thanks.
the floor is yours. Thank you.
Can you see my screen now?
Yes.
Okay. Thanks, Kevin, and thanks for David and Magali for their talk about copyright in Israel and in Europe. And I'm also I will focus on the copyrightability and the ownership of copyright in China. So first of all, I want to show you 2 trial cases. Although China is not a communal country, I still want to show you these 2 cases to help understand the current legal situation of copyright protection for AI-generated outputs in China. The first case involves the first decision released in China regarding copyrightability of output automatically generated by computer software. The plaintiff film published a report on its WeChat official account, and the report was partially posted without permission on Baidu's, the defendant's platform. The defendant argued that the report was automatically generated by data analysis software, and thus is not protected by copyright for its lack of originality. The court first confirmed the originality of the report because the report satisfied the formal requirement of written works, showing selection, judgment, and analysis of relevant data, but the court eventually denied the copyright protection because based on their analysis, the court found that neither the developer nor the user of the software created the report. And according to current regulations in China, copyrightable work must be created by natural persons. The next case was also in 2019, but in a different district court in China. In this case, the defendant issued an article written by an intelligent writing software named Dreamwriter, which is developed by the plaintiff's affiliate company and used by the plaintiff to generate the article without permission of the plaintiff. The court first recognized the selection, analysis, and judgment about information and data, and therefore proved that the work had a certain degree of originality. Then the court analyzed the processes of generating the article and concluded that the plaintiff's human being intellectual activities are directly connected with the originality of the work. So although these two cases are controversial on the decisions, but the framework of determining copyrightability is generally the same. So regarding the first question, do AI-generated outputs belong to works under copyright law in China? The Chinese practice includes two steps. Step one is to determine the originality of the output. There are some relative objective standards, including formality, requirements, and creative effort, such as selection, arrangement, judgment, or analysis of data. And the second step is to check if there is sufficient human being intervention, which is the key and also difficult part, because under current Chinese law and regulations, the creator should be a natural person, which is still a prerequisite. And the difficult part is that if you need to you need to give insight into the process of creation of the work and determine the degree of human intervention. But luckily, in current situation, although AI models are becoming powerful, almost all creation of work still need humans involvement. AI still needs serve as a tool. So current copyright law framework can still deal with this situation. But in future, when the day comes that the content can be generated autonomously generated by AI, I think the current law framework may need a reform. So next, when the copyrightability is settled, it comes to the second question: who owns the right? What is for sure now is that the owner should be human being rather than AI, the machine. So since according to the definition for authorship and the current law in China, the author needs to show creative intervention and intention and have the ability to enjoy the right and take the responsibility. But which role should the right be exactly attributed to? There's no definite answer yet. In the second case, the Tencent case I just talked about, the court decided that the user of the AI software owns the copyright. But personally, I think the ownership should be determined case by case, taking into the degree of creative efforts and the balance of benefits between the parties. So that's what I want to share about the copyright in China from Chinese perspective. And next, I will translate smoothly to patent protection of generative AI invented relations in China. As you can see, Here I want to show you some general ideas of patent, AI-related patent in China. Then the roadmap shows the generalist natural language model industry trend in China. We can see a lot of Chinese companies have invested throughout different aspects and different levels in the chain. A Chinese consultant agency carried out an interesting test on the intelligence of natural language models. It can be seen from this diagram, from this chart, that the models developed by Chinese companies. Here you see the second one is developed by a Chinese company, Baidu. It is not as smart as ChatGPT yet, but it's very close to the first one, ChatGPT. Their scores are quite close. And this diagram shows patent application data in 2022 in different technical fields of AI in China. More than half of the patent applications are deployed in deep learning, smart cloud, and computer vision. Patent applications regarding deep learning, the basic algorithm sold since 2016. So who filed the most patent applications regarding generative AI in 2022 in China? This chart gives the answer. The company include the traditional internet company like Baidu and Tencent, and also communication company like Huawei and Oppo, and also top companies in other industry like finance and electricity. To protect the technical aspects of AI-related inventions, tool includes patent, trade secret, and software copyright. They have different pros and cons. Patent is powerful as it provides exclusive rights. Even if some others make the same innovation on their own, they're still restricted. Patent protects devices that are not suitable to be maintained secret. It can also protect against reverse engineering. The main drawback with patent is that it cannot protect anything but only technical solutions. To the contrast, you can almost protect anything and trade secret. The problems are that it might be practically hard to prove secrecy and maintain secrecy given the widely used open source code and the high turnover of technicians. Moreover, it's often hard to prove the value of the trade secret. Software copyright is an easy and fast way compared to patent and trade secret. The protection period is between 50 years. It's also longer than that of patent. However, it only protects the expression instead of the ideas per se. The competitor can easily bypass the copyright by some modification to code. Therefore, patent is still a dominant tool in the protection of AI-related inventions. Before introducing China's examination policies on AI-related patent, it's better to outline features of AI patent to help understand what is special. Generally, it's partially like common patents related to computer software. A lot of AI inventions are embodied as software programs. Secondly, AI-related techniques develop fast, which requires a fast grant if we apply for a patent. Thirdly, some innovations involve algorithm improvement that is prone to be rejected as being mental activities. And fourth, the model for machine learning black box, which makes it difficult to evaluate the inventiveness of a solution if the improvement lies in the model per se. Also, it is difficult to provide a comprehensive protection because some innovations cannot be protected by patents. And lastly, the infringement detectability may be poor. In our local examination practice for AI patents, currently the biggest challenges are patentable subject matters and novelty and inventive step. In terms of eligibility, we need to figure out if some improvements on the algorithm belong to mental activities that are not protected by a patent. We also need to define what makes a tactic solution. In terms of novelty and inventiveness, we need to answer if we should exclude non-tactic features. For example, algorithm features from the evaluation, should we consider the contributions from the non-technical features? But today, since the time is limited, I will focus on the eligibility issue.
Okay, thank you, Dan. So I think
sorry,
yep.
it's not. I'm not finished yet. Sorry.
Okay, please go ahead. Yeah.
Okay. Current framework for eligibility, novelty and inventiveness, including Article 25, which lists eligibility subject matters, and this Article 2.2 defines what makes a patent, and Article 22 and 23 are regarding novelty and inventiveness. And recently, the Chinese government has made amendments to the guidelines for patent applications. In the amendment to Chapter 9 regarding software-related inventions of the guidelines, the office has decided that the solution, including all technical features and the non-technical features, should be considered in its entirety. There would be no splitting or excluding. Also, in the 2021 draft amendment, the office discussed the effects of improvements on internal performance of a computer and on user experience. So here's the examinations. Here are the examination steps on eligibility. So first step is the patent related to rules and methods for mental activities. If it is a pure abstract algorithm, then no correlation with the specific application, then it should be ineligible, and otherwise go to step 2. The step 2 is to decide if the invention belong to technical solutions, and what features, including technical features and algorithm features, reciting the claims, should be considered as a whole. And to decide if it satisfies the technical solution standard, you need to have technical problems, means, and technical effects. So for algorithm features, the steps should be closely related to the technical problems to be solved, and the data should define the technical meaning in the field. And last, the implementation should reflect laws of nature as technical effects. Then in this way, the patent is eligible.
I'm sorry, Dan. I'm sorry to interrupt, but I think we should pause right here, and then go into the Q&A session to allow to more interaction with the panelists and the audience.
Okay.
Again, thank you so much, Dan. So we're open the floor to the audience. If any questions coming up. If there's none, I personally have a question for, I have 3 questions for each one of the panelists, but due to the time, I think I'm just asking one of them. The question is going to David. So as a IP litigator, do you see if the generative AI would affect the enforcement work, and in what way, if there is? And would the generative AI bring more impacts or benefits, or more specifically, would it replace or streamline litigators' work?
Well, that's an excellent question. You know, I believe in the near future, the work of litigators will not be significantly impacted by generative AI systems. However, when shifting our focus to the long term and as to how these technologies eventually come into play, this perspective will become irrelevant. It's astonishing to think that just 6 months ago, nobody even knew what ChatGPT was. We therefore need to engage our imagination and prepare ourselves for a radically different future, generally and career-wise in particular. When the CEO of a drilling company asks her sales team about customers' preferences and desires, they all might respond with a desire for fast, cheap, and efficient drills. However, she will correct them by pointing out that such perception is misguided. What customers truly want is a hole in the ground. Similarly, when patients visit a physician, they don't necessarily require surgery, treatment, or medication. Their ultimate goal is to be healthy. This is the perspective we should adopt. Clients do not wish to go to court, to review agreements, and so forth. They want efficient, quick, and financially viable solutions. So if experts predict that around 2030, advanced AI systems will provide clients with better solutions, clients will naturally opt to seek guidance from AI generative systems. And as young legal professionals, it is crucial that we prepare for what lies ahead and contemplate how we can successfully integrate into this new and challenging area.
Great, thank you. All right, we're now just 9:56. I think we'll just stop here for now, and I really appreciate all three speakers, Magali, Dan, and David. And I'm so sorry, Dan, I just interrupt you because of the time, for your sharing during the past hour. And thank you all viewers for join us for this first session. If you have any more questions or comments, including the panelists or the viewer, the audience, please do join us in the IP Cafe session in the afternoon CST time. And so we can keep the conversation, keep continuing and running. And lastly, please stay tuned. There are more other interesting IP sessions to join for the rest of the day. And I'll see you. We'll come back in 3 minutes at 10 a.m. CST. Thank you very much. Thank you, the panelists. Thanks for the viewer. Thank you.
Thank you, Kevin.
Thank you very much, Kevin.
Thank you.
Thank you also. Please head to just a short break, and we'll come back in 3 minutes for the second session. Thank you.
Hello again and welcome back, everyone. I hope that you got a quick 3-minute break, and it's sort of one of our new features for this year, which is to incorporate a little break to just give you a bit of time to reflect a little bit, grab refreshments, before we start our next session. So with the generative AI session, I hope you found it really useful. I know I learned a lot of things, more than 10 things today, I think, in just that one session alone. And so we're continuing the trend into what's trending and moving along to another very interesting topic, which is the UPC, which we all for sure have known about, and that's happening in Europe at the moment. So I'm very pleased to introduce your moderator for this session, Halise, and I'll hand across the session to you to introduce our speakers.
Thank you, Debbie, for the warm welcome and introduction. Hello, everyone. Welcome to the session, The New Frontier, Unified Patent Court, Who, What, Where, How, and Why. I would like to begin by introducing myself and the speakers shortly. My name is Halise from Turkey. I'm working as a patent agent at Stock Intellectual Property Services since 2011. I am a member of AIPPI since 2015 and one of the founding members of Young AIPPI Members Committee since 2020. I am now also the Secretary General of AIPPI Turkey, and I'm happy to meet you all and hope to see you all in Istanbul in October. And as for our speakers, Dr. Niklas Gajek is a senior associate at the Noir IP litigation team in Germany, which he joined from a major US law firm in 2020. At Noir, Niklas litigates a wide range of complex patent disputes, particularly in the field of standard essential patents, with much of his current work focusing on the field of communications technology. He also has considerable experience in a variety of other fields of technology, such as network and network security technology, virtual overlay technology, or circuit systems. Niklas's knowledge and experience also encompass adjoining fields of the law, such as competition law and the protection of trade secrets. With a doctoral degree in the field of trade secret law, Niklas continues to advise clients, publish, and speak frequently on all issues revolving around trade secrets and patent protection. Niklas is also a member of the AIPPI Standing Committee Standards and Patents and several other IP law organizations, such as the German Association for the Protection of Intellectual Property. And our other speaker, Jiří Slavek, is a dual qualified Czech and European patent attorney and a European patent litigator registered at the UPHC, based in Prague, the Czech Republic. He has more than 8 years of experience as an in-house patent counsel in the pharmaceutical industry, where he is involved in various IP aspects of generic and value-added medicines developments. Currently, he is part of the IP team at Adalvo, a leading B2B pharmaceutical company, and in his free time, he also participates as a freelancer, mainly in IP educational activities. Before leaving the floor to our speakers, I'd like to mention that please write your questions in the chat box below. The questions will be answered at the end of the session. Jiří and Niklas, the floor is yours. Thank you.
Many thanks, Halise, for the kind introduction, and welcome to everyone. Thank you for joining our session, which is, of course, about the new frontier here in Europe, the Unified Patent Court. Before we're going to do a deep dive into the topic, let me just quickly lay out the broader picture here. So the European patent policy, of course, ranges back far beyond the UPC itself, which has its origin maybe about 10 years, even a little bit more ago, and which Jiří will get into in a second. And it's part of so the UPC, while not being EU policy by itself, so it's of course, it's a bigger international project. It is part of the European patent policy, and therefore part of a broader picture here, which encompasses also, for example, policy initiatives in fields such as FRAND, SEPs, or pharma, SPCs. And there's actually been a lot going on in that parts as well, with recent draft regulations being published and debates going on also for at least the last 10, in some cases, 20 years. So overall, we have new policies coming up that aim to provide a comprehensive unified means of patent protection and an increased use of patented technology, for example, by promoting SME access. And although they have different timelines, and although the UPC is by itself a very particular and special project that is not an only EU-only project, but encompasses international treaties that go beyond the European Union, we can see that there is an overall concept, and that is the overall concept of the European Union of an ever closer union, meaning that the member states are actually more and more unifying their legal codes and creating an overall policy, and that we can also see in the patent landscape. So now to the UPC, and I'm happy to hand over to my colleague Jiří Slavik to show you how the UPC itself came to be.
Thank you very much, Nicholas, and again, Alistair, for the kind introduction, and for the AIPPI for being able to contribute today on such an interesting topic. So in order to show you how enormous and longly awaited this whole change with the UPC and the unitary patent is, we want to show you a bit of a history. The discussions about a unitary patent in the EU began already as early as 1949, probably. And in fact, already the first proposal on the European Patent Convention, as we know it today, it foreseen the creation of a unitary European Patent Court with jurisdiction to hear appeals from the EPO and having competence to interpret the EPC. This obviously did not happen. And there were discussions going on several years later, many times, which almost always failed until now. One of the last proposals, actually, which is the last point on this slide, was the proposal on the European Patent and Community Patents Court. This was open also to non-EU member states, and this was actually held incompatible by the Court of Justice of the EU with the European treaties. This is the famous opinion 1 of 2009. And some of these issues which were raised in this opinion were adapted in the latest proposal, the agreement on a unified patent court, which we will be talking about today, which was signed by the 25 EU member states in 2013. And after all these years, from perhaps 1949, came into force on the 1st of June 2023. We can move on to the next slide with us. Thanks. So when we talk about the unitary patent system, this new system consisting of a unitary patent and a unified patent court, we talk about the whole unitary patent package. This was actually adopted at a EU level, and it comprises several levels of legislation which create this new system. We have a new regulation on the unitary patents. You may be wondering, and we will show a map on the next slide showing you the territorial differences among the EU, that actually this new system is not applicable in the whole EU. If you just go back on the previous slide, yes, thanks. And why is this system not applicable to the whole EU is the fact that it was adopted under what we call the enhanced cooperation. So a group of states has agreed to further develop within the patent protection and create this unitary patent system, but it will not be, at least for now, applicable in the whole EU. We also have a second regulation, which consists of translation arrangements, which are a specific topic to the UP itself. And we have also the agreement on the Unified Patent Court, which, as Nicholas said, is an international treaty. So it's not part of the EU law, but again, the countries agreed to create this common court, and we will talk about this in more details later on. We also have a regulation which amends the Brussels recast regulation about the jurisdiction and competence of the Unified Patent Court. And as you can see, and as we discussed before, the implementation of this new system took several years. And even after the signature of the UPC agreement in 2013, it took 10 years for the system to actually enter into force. And some of the issues which were raised during these periods were that there were actions for annulment filed by Italy and Spain about these new regulations, which have failed. Italy afterwards then joined the system as well. Spain filed 2 other cases trying to challenge the regulations at an EU level, which then failed again. But Spain, for now, is still not part of the system, as we will show later. Then we had issues, although all things were seemingly resolved, then Brexit came, which created a lot of issues in the UPC system, because the UK was part of it as a new member state. And a lot of things were dependent on participation of the UK. Now, most of these issues seem to have been resolved, although it cannot be ruled out that some parties may wish to attack the validity of the whole system based on the Brexit. We don't know that. Has officially deposited its ratification of the UPC system. The system entered into force on the 1st of June this year, as we said. So if we go on the next slide, this is the map showing the territorial coverage within the EU of the new system. So as we said, the new system is not applicable in the whole EU. We have different countries with different ways they are participating in the system. So we have the blue countries where the system is applicable. These countries have fully ratified the UPCA, and the unitary patent and the unified patent court are fully available in these countries. Then we have the yellow countries, which, although they participate in the enhanced cooperation, they have still not ratified the UPC agreement. So these countries, for the time being, are not part of the system, but it is expected that they will join sometime later. We also have within the EU the red countries. These countries are currently not part of the system as well. Some of them are not participating in the enhanced cooperation. This is Spain. We discussed that they have filed several actions for annulment, and they, for the time being, they are opposing the new system. Croatia, which was not part of the EU yet when this new system was enacted, so they are not yet participating. They may join probably in the future, let's see. And Poland, which, although it participates in the enhanced cooperation, they have not even signed the UPC agreement. So not even ratified, but they have not even signed. So they are out of the system as well. Lastly, we have the green countries. These are countries which are outside of the EU, so they are not eligible to participate in the new system. However, they are still part of the European Patent Convention, so you may still obtain European patents at the EPO for these countries. Going on the next slide, we want to briefly talk also about the unitary patent, which is part of this new system. So what is the new unitary patent? So when we talk about it, it's officially the European patent with unitary effect. So we talk about a new type of a European patent, which is available for the patent holders as of 1st of June 23. It is designed to remain optional for the patent holders. So the patent holders may voluntarily select to have a European patent with unitary effect, or they may not. We will discuss that later on the next slide. The unitary patent provides for a simplified procedure for obtaining protection in these contracting member states, so these 17 countries where the EUP and the UPC are applicable for now. It probably be able to provide protection at lower costs in these countries because there is a single payment for renewal of the patent at the EPO, and you do not need to go and validate nationally, as is the traditional way. However, this also depends on the territorial extent where you seek your protection. So we have to remember that there are big markets and big countries which are not yet part of the system. For example, the EU, Switzerland, Spain, Poland, all these countries are outside of the system. So depending on in which countries you are seeking your protection, this new system might be financially advantageous for you, or it may not. The unitary patent will have a unitary effect. This means that it will have uniform and equal effect in all the 17 contracting member states, the states in blue, which we showed in the map previously, And this is usually referred to as the all the eggs in one basket concept, meaning that you either have everything in these own countries or you have nothing. You cannot go into the situation where you have protection in Germany, but you don't have protection in France or vice versa, because you have this unitary character. And the patent, of course, may only be limited, transferred, revoked, or it may lapse in the whole territory of these 17 member states. That's why all the eggs in one basket. Now, licensing would still be possible only in part of the territories. And one of the requirements to be able to obtain a unitary patent is that you need to have same claims in all the 25 participating member states. So this is a bit of a difference, not in the 17 states where the system is currently in force, but when you have your European patent granted, you need to have the same claims in respect of all the 25 participating member states. So for example, including also Poland, where the system is currently not in force. On the next slide, we want to talk about briefly how you actually obtain this European patent with unitary effect, or shortly unitary patent. So I mentioned before that we have the traditional way, which most of you are very much familiar with, is that when you obtain a European patent, when you have a grant by the EPO, you have to basically go and validate your European patent in each country where you seek protection. So although we have 39 contracting member states at the EPO currently, you would need to go into each country and validate the patent where you want protection. Now, as of 1st of June 23, there is this new way, which, as I said, will remain and is optional for the patent holders, which may then choose for these 17 contracting member states how he wants to seek protection there. So he has two options. Either for these 17 contracting member states, he will select a unitary patent. That means that within 1 month of the publication of grant at the EPO, he has to request the unitary effect, meaning that in these 17 member states, the blue countries, he will obtain a unitary patent. And then he can decide to nationally validate in the remaining states, for example, the UK, Switzerland, or Spain, as we discussed earlier. On the other hand, he may still choose to go the traditional way. So in these 17 contracting member states, he may choose to validate the European patent nationally, as was the case before, and also do this in the remaining countries. So these are the two options that the patent holder has a choice. As I said, the unitary patent will remain optional. It will not be mandatory. And now we can move to the Unified Patent Court, which Nicholas will talk about in more detail. But just to show you how the court is organized, so here is the official picture from the website of the UPC. So we have the UPC, as mentioned before, as an international court, which is a common court to the 17 EU member states, where the system is enforced currently. And we have a decentralized courts of first instance. So we have different local divisions, we have central divisions, we have regional divisions. And Nicholas will talk about the competencies and the jurisdictions for the divisions. We have a central court of appeal, which is located in Luxembourg. We also have something which is called a patent mediation and arbitration center, which is set up in Lisbon and Ljubljana in Slovenia. What is also important to note, as the last thing on this slide, is that the UPC, as mentioned, is a court common to the EU member states. So it has the same obligations as any national court of the EU member states. And this is actually one thing which was raised previously, as I mentioned, the opinion 109 on the previous community patents court, which contained some things which were incompatible with the EU law. And it has been highlighted in the UPCA as well, that because the court is a common court, it has the same obligations, so it has to also perhaps refer questions to the Court of Justice of the European Union when the EU law is at stake. So this is one thing which is particular to the UPC as well, as is to any other member state court. Now I will leave back to Nicholas to go into the details of the UPC.
Many thanks. So the big question now is how does the UPC how does the UPC stand when compared, for example, to the jurisdiction of the member state courts? because of course we still have national patent systems, and these have their own courts. And we may have situations where there is a unified patent court on the one hand dealing with a European patent, and a member state court also dealing with a European patent. And the UPC agreement and the other agreements related to it, they actually deal with that on a principle level by giving exclusive jurisdiction to the UPC. And that exclusive jurisdiction not only extends to the unitary patents, so the European patents with unitary effect, but it also extends to the European patents. So the patents that actually, after being granted, are subject to national law. But that only applies as far as no opt-out has been declared. And if no opt-out has been declared, then of course there is a unitary application of the that is done by the UPC. And there's basically just one exception, and that is when the member state jurisdiction prevails. So there is no exclusive jurisdiction of the UPC if cases are already pending before member state courts. That on the one hand. On the other hand, we have, of course, the opt-out that I already mentioned that basically withdraws the EP from the jurisdiction of the UPC. So there's these two instances where we still have a member state jurisdiction with regard to EPs, so European patents, not European patents with unitary effect, unitary patents, as Yuri already called them. And then we, of course, have another big issue, which is what do we do if we have one EP case pending in a member state, but the EP not being a subject matter of litigation in other member states. And if we have no opt-out in that instance, actually, we would still have a jurisdiction of the UPC, although there is already pending national litigation relating to one national part of this European patent. So it's a little bit complex because we always have to remind ourselves that we are talking about the European patents that actually, after being granted, divide into national parts that are each subject of national court jurisdiction prior to the UPC coming into force. So, for example, we have a situation where we, on the 29th of May, just a couple of weeks ago, have litigation filed, for example, in Germany, again, based on an EP. So an EP infringement case. And then now it is, today we have the 21st June, the UPC is already in force. And now other litigation based on this EP is filed before the UPC. And then we would have the situation that the UPC will, of course, still be able to deal with this litigation, but only to the extent that the national court in Germany is not already dealing with it. And to ensure that, the UPC would have to carve out these existing, already pending at a national level EP matters. Apart from that, the UPC will still have the opportunity to fully decide on this EP, because we are now talking about a situation where there is no opt-out. So the EP as a whole is not withdrawn from the UPC system, but is still in the UPC system. Meaning that the remaining subject matter that is not discussed at the national level, that is not pending before the national court. For example, we have a different infringement action. We have infringement of validity in other UPC member states, or we have infringement alleged against another defendant. That is all subject matter that can still be discussed before the UPC, that will still fall within the exclusive jurisdiction of the UPC. So as you can see, there's a complex interaction going on between UPC and member states courts, and also particularly in the current situation where the UPC just went into force. If we want to make this more simple, then as a plaintiff, for example, we can simply withdraw cases at the national level as far as that is possible. For example, in German civil procedural law, you can do that before the oral hearing without the other party having to agree to it. And then you could bring the full case before the UPC, also including the part that was priorly pending before a national court. So now, assuming we have jurisdiction before the UPC established, the next big thing to talk about is which chamber is actually responsible for it. So where do I land? Do I land in Munich? Do I land in Paris? Do I get to go to Milan or somewhere else? So for validity cases, there's actually a couple of different rules that address this question. So central division has primary competence. Nullity counterclaims can also be decided by local or regional divisions, which are the ones that deal with the infringement claim. So counterclaim always implies there is a claim. The claim is usually an infringement claim brought before local or regional division. And the local and regional divisions also have the option to refer the nullity counterclaim or whole proceedings, so including infringement case, to the central division. So we have a primary responsibility, primary competence at the central division for the validity matters. And then we have the option to deal validity and infringement parts of a case together at the local or regional division. So in terms of infringement, there's also a couple of divisions that have the competence to deal with a case. This is primary local or regional division for the UPC member states where the infringement took place. This can be one, this can be several, of course. Can be the division at which the defendant has its seat. And if we have infringement in a UPC member state where there is no court seat, so no regional or local division, and if the defendant has no seat in a UPC member state, then the central division will also deal with the infringement case per se. So far as to competency. And then just to have a short look at the litigation timeline, cases proceed in 3 stages before the UPC. So the first thing that is dealt with are preliminary objections. This is the first month after the service of the complaint, and that relates to formal issues. So for example, questions of jurisdiction, just as the ones that we've discussed right before that, questions of language, and that's laid out also in Rule 19 of the Rules of Procedure. Then that is followed by a written procedure that can take from 6 to 9 months. And it entails submission of at least 2 briefs per party. Same for counterclaim. And then we have cases where there's primary the infringement claim, then we have the counterclaim for nullity brought by the defendant. And then, for example, we have auxiliary requests brought by the plaintiff again, which provide to uphold the patent in case the main claims as laid out in the patent are found not to be valid. And that, of course, leads to a stack of briefs. So we have brief for counterclaim. Then we have to, let's start with the claim. We have the complaint. Then we have the response to the complaint, which is usually also the counterclaim against the validity of the patent. And then we have the response to that counterclaim and reply to the statement of defense and so forth. So this can actually take much longer, especially if we have a counterclaim being brought for nullity of the patent. Hence, this is a flexible time frame, 6 to 9 months. And we also have discovery options, which I will go into detail right now. And this whole written procedure leads up to an interim procedure and an oral hearing. And the interim procedure, there are also settlement options are explored. There is one reporting judge that handles the case management, and interim conferences can be conducted. And there's optional interim hearings where also expert and witnesses may be ordered to attend the hearing later on, or may even be taken into account at the interim hearing already. So following written and interim procedure, there will usually be a decision that has to come within 6 weeks after the hearing, according to Rule 118.6 of the Rules of Procedure. And the court may render its decision on the merits of the infringement claim on the condition that the patent is not revoked if parallel revocation action takes place. And you can apply for preliminary enforcement and preliminary enforcement of the judgment, meaning that even if there is an appeal case, you can still enforce the claims. And enforcing the claims is actually a separate part that follows after these after the decision. So we have a full proceeding afterward that is rendering of accounts and damages, and that can take up to 1 year after the decision. As you see below, I slightly skipped the trial part, which is the oral procedure. Not much new. That is actually, it follows a lot also from the German legal tradition, although it's a combination of continental European and UK traditions. And you can look it up in Rule 112 of the Rules of Procedure. And it's usually just 1 day of trial. So most of the work will be done in the written procedure before. And if there's still work to be done, then you can have an interim hearing. You can extend the oral procedure. Of course, there also will be a cost decision. And then that's basically it. So if you're lucky, you can get the whole case over within a year. And that includes a decision on infringement of the patent, that includes decision of validity of the patent. Even if they are combined as laid out in this timeline, of course, you can also separate them. You can also actively engage in a nullity complaint, even if there is no infringement complaint. This is just basically the complex and probably most typical approach that we will see. So handing over now back to Jiri, which will give us an overview over the material law provisions that are actually applicable to the unitary patents, and that the court will also have to apply in these procedures.
Thank you very much, Nicholas, for going through and explaining the procedural timelines. So as mentioned, there are some substantive provisions directly in the UPC agreement, and actually these provisions, at least from the wording of the UPC agreement, apply not only to the unitary patents but also to classical European patents. So at least from my view, there is some uncertainty on how this going to be applied by the member states courts, because as we said earlier, in the countries where the UPC is in force, the countries have ratified the unitary patent court patent agreement, which is now part of their national law. And it's to be seen how the courts of these countries will apply the UPCA and the national law and the national case law in cases of traditional European patents which are in force in these countries. Irrespective of that, here are highlighted the main provisions relating to substantive patent law. So we obviously have the direct patent infringement provisions. There is nothing surprising there. We have the indirect infringement provisions. Here, I would like to mention that the double territory requirement, basically, which we normally have for indirect infringement, is actually a bit broader because it's applied to the whole territory of the contracting member states, not only to the single specific one country where you try to argue indirect infringement. In this case, the whole states, the blue ones, which we showed on the map, the whole territory is applicable for supplying, for offering, and for putting into effect of the product protected by patent. We also have an exhaustive list of exemptions from patent infringement in the UPC agreement. It's an exhaustive list. It contains several provisions. The notable ones are the magistral formula for preparation of pharmaceutical products, individual ones in the pharmacy. We have also a reference to the border exemption, which actually directly refers to the Article 10 of the directive, which contains provisions of the border exemption. Here again, there is a bit of a issue that normally this directive was implemented in the member states differently. We have different case law in the contracting member states. And now we have reference to this article in the UPCA, so it's questionable whether the borrower exemption is actually less broader than it has been previously as interpreted by the contracting member states. We also have a new proposal from the European Commission on a possibly new borrower exemption, so this will have to be incorporated later on. We have also reference to prior user rights in the UPCA. Now, these remain national rights, so they will still be limited for the territory of the contracting member states where the prior use has occurred. So they will not be pan-EU-wide or pan-wide among the contracting member states. On the other hand, the exhaustion of rights, which we have in the UPC as well, this is going to be still pan-EU-wide exhaustion, as we had previously interpreted by the Court of Justice of the EU. The exhaustion of rights will remain pan-EU-wide based on the European single market. If we go on the next slide, then the next thing we wanted to briefly discuss is the SPCs. Now, you may know that what supplementary protection certificates are, that they are a separate right of its own kind granted by each national authority separately, and that for these eligible patents for which you can obtain SPCs, the SPC is able to prolong the patent expiry of up to 5 or 5.5 years. For now, the UPC is also competent to hear cases regarding the supplementary protection certificates, which are issued nationally. So cases regarding both infringement and validity. We don't yet have unitary SPCs. Although we have a unitary patent, we do not have a unitary SPC as a complement to this patent. So even though you may obtain SPCs for unitary patents, you will actually go a step back and you will go back to national rights. So if you're playing a European patent with unitary effect, which has unitary effect among all the contracting member states, if you obtain an SPC, granted one for this patent, then when the basic patent on which the SPC is based has expired, you will go back to national rights. So each country will have its own national SPC. Based on a European patent with unitary effect. Nicholas talked about the opt-outs, how you can opt out a patent from the jurisdiction of the UPC. You can also opt out an SPC. However, you cannot do that independently of the patent. So the SPC will always follow the fate of the basic patent it is granted upon. And there will be the same rules as Nicholas explained for the parallel jurisdiction of the contracting member states and the UPC as for European patents. However, as I said, we don't have a unitary SPC right now, but we have a proposal from the European Commission. It's actually 4 new proposals for both unitary and centralized supplementary protection certificates for both medicinal product and plant protection products. We don't want to discuss this in detail because it's a separate and specific topic, but in general, we want to show you that there is a proposal for a logical follow-up of unitary patents to also unitary SPCs. Now, just very briefly, the proposal on the unitary SPCs, it will again not be mandatory for unitary patent holders to apply for unitary SPCs. There may be some mandatory ways where you to obtain a sort of centralized SPC, but which again will be granted by national authorities and will become a national right. So these are 2 different proposals which there are by the European Commission, but the unitary SPCs are not foreseen to be mandatory in the same way the unitary patents are not mandatory. Both the centralized and the unitary SPCs are sought to be handled by the EU IPO. The unitary SPCs will actually be granted by the EU IPO. So the EU IPO will have will have to create a new SPC division, and it will not be the EPO, which is handling the patents, but the EU IPO, which will handle the SPCs, which are based on European or unitary patents. There will also be a separate opposition procedure at the EU IPO, or there could be probably in the future a nullity procedure filed against these unitary SPCs at the UPC as well. So it remains to be seen when this new complementary system of unitary SPCs to the European patents will enter into force. But from the experience in the past, it may take some time. Handing back to you, Nicholas.
So thank you. And for the final building stone that we're going to discuss today is actually the FRAND directive, which was published almost at the same time or at the same time with the SPC draft regulation. So this FRAND SEP draft regulation actually concerns another building stone that is not exclusive to the UPC system, but that will play an important role for the UPC system as well, because it affects the enforcement of patent rights through any jurisdiction, through any court, basically. Let's go back to the basics. What are we talking about when we're talking about SEPs? These are standard essential patents, so technology that is patent protected, that is required to use to access a specific market. For example, if you have a smartphone that uses LTE, 5G, any of the technologies, then your smartphone must also use the patents that are incorporated into the, for example, LTE or 5G standard. So, and that is a cartel. That's basically, something that would usually be prohibited by antitrust provisions, because you wouldn't have all of the most important technology companies in the field cooperate and create a unified standard, because then they could set the prices in whatever way they want. So, and to accommodate for that exemption to antitrust law, that it's actually allowed to create these standards through mutual cooperation, we have the FRAND defense as a primary response, and other competition law rules that apply. And FRAND basically requires the patent holder to grant fair, reasonable, and non-discriminatory licenses to these SEPs. And that is also what the EC's SEP draft regulation is addressing. And it is providing for a few new, very revolutionary actually measures. And it's highly debated. And as Yuri already said, with regard to the SPC draft regulation, it may take some while if it is enacted at all. So the draft SEP regulation tries to provide more fairness in licensing and simplify the process of establishing FRAND rates, which has been an issue for as long as there are SEPs, by institutionalizing SEP-related processes at the EU IPO and substantially further developing EU competition law policy. So, for example, it requires SEP owners to facilitate market access through licensing that is actually favorable to SMEs and new market entrants, so small and medium entities. So it's a way of positive discrimination, if you want so, and that's part of the draft regulation itself, Article 62 in particular. And since this is European Union law in draft right now, but at some point it will be enforced, it's very highly likely to also affect the UPC's application of competition law. And there are actually a lot of open questions in that regard, particularly, does the UPC even have the competence to apply competition law by itself? It's not explicitly written out, but then again, the member states are EU member states, and the European Court of Justice's CJEU's rulings will apply, and they also lay out these FRAND principles. So my best guess is yes, it will also apply to UPC. And that having been said, we will have a great session headed by Lucy Wiles following this session, which is the sole topic of this later session will be the EC's SEP draft regulation. I can only recommend to join, and then we can discuss this a bit in further detail. So far, we would be happy, Yuri and I, to answer any questions you might have with regard to the UPC and the UPC application that we have been seeing since the 1st of June. And maybe as a last incentive, Yuri actually made this wonderful overview of the cases that are currently pending before the UPC. Yuri, maybe you want to introduce it.
Yeah, this was actually the last slide we wanted to share with you after going through this very heavy topic of the UPC and unitary patent. So the first cases which are actually visible in the risk management system as of the 1st of June 2023. So within the first 20 days, the court has opened its doors. So this is a very fresh overview as of today's morning, what is visible in the CMS system. So we have 16 cases which are visible. There may be more cases, but it probably takes some time for the cases to be visible in the system. So majority of the cases are infringement actions. 13 cases are infringement actions. We also have at least 3 revocation actions which were filed at the UPC. 2 of the revocation cases were actually moved from the Paris Central Division to the Munich Central Division, which goes back to the competence and jurisdiction discussion we mentioned a bit earlier. So the distribution between the divisions is based on IPC classes of the patent. It should be the first class which is listed on a granted patent. So in case the parties get it wrong or the court considers that the parties got it wrong, they may move the competence. So this is what probably happened in the 2 revocation cases. Interestingly, one of the highest value of the case, which we have found, was 100 million euros, which is quite a nice value. The value of the case at the UPC affects, for example, the court fees or also the ceilings for recoverable costs for the winning party. I think that's all from our side on this topic, and we are happy to take any questions.
Thank you, Jerry and Niklas, for this very informative presentation. In my opinion, as listeners from all countries, whether included in this UPC or not, the session was very useful to understand the system better. Yes, now we can go with the questions, if any. We have a little time. If not, I have a few questions to you both. Okay, maybe I can go first. Which cases may be better suited before a national court instead of being brought before the UPC?
You want to take that, Nicholas, or? Yeah,
Sure. So pardon, I was just responding to a question in the chat. Yeah, so what happens if, when should I go to the national court instead of the UPC? Is that the question, Halisa? Then I think the answer would be, it really depends on the case, and it especially for variety of factors. One of the most important factors is probably costs, because UPC can be more expensive than a national court. There's actually a table at the UPC homepage where you can find out how expensive it is going to be, where the court fees are laid out, and it's based on a fixed fee combined with a value-based fee when the value of the case is above the set ceiling of 500,000 euros, for example. So that is an easy calculation exercise, and then you have to look at to which national courts would I have to go? Is it just one? Is it 2 or 3? And usually, if you have 2 or 3 national courts that you would have to go to enforce the patent in every jurisdiction that you want to enforce it, then it might make more sense to go to the UPC. Yeah, but there is no definitive answer that is applicable to every case.
Thank you. I'm just waiting for other people to ask their question, if any.
Sure, Halisa, this is Debbie here. I'll just jump in and ask a sort of, maybe not a theoretical question, but more a sort of in practice question, since you have sort of Niklas, who comes from doing more litigation, and Yuri, your background, being in-house in Adalvo. I guess it's just, what excites you about the UPC? I know it's new, we have lots of questions in the air still, but sort of what excites you from your perspective as a practitioner with the UPC, and what sort of doesn't excite you or what concerns you with the UPC. I think it would be really interesting to hear both your opinions on that.
If I may start, Nicholas, like coming from a generic background, I think there's probably more concerns than excitements. There's a lot of uncertainty. I try to point out some things which are uncertain during our slides, but there is much more behind. And we do not know what will happen. We do not know how the judges will decide. We have national judges participating in the panels at the UPC, so we do not know whether they will take their own national case law and implement it to the UPC, or whether they will decide it differently. Also, the provisions in the UPCA and in the rules of procedure are sometimes contradicting a bit each other, and they are not clear how they will be implemented. So for me, the exact word for the UPC is uncertainty. That would be my view. Happy to hand over to Nicholas.
Yeah, the uncertainty is a big issue. I'm actually coming from a different perspective, which is very formidable. So you and I, we work together perfectly, because he has a patent attorney background and a lot of generics experience, and I'm more on the litigation side and do a lot of technology. So actually for me, there's a lot of excitement, and I'm really looking forward to the first technology cases in particular. And as I already mentioned, one big thing will be the application of FRAND principles. So how do I deal with SEP cases? To what extent does competition law come in? Will we go before the CJEU, so the European Court of Justice, actually, to discuss some of these matters at some point? And I personally hope so, of course. And yeah, there will be a lot of things to decide. The procedure itself bears a lot of risks also, so that's a concern that I have as a practicing attorney as well. In particular, you will have to submit a lot of evidence in advance. So the UPC system could be more strict on that, and also with regards to delayed submissions of evidence and so forth than, for example, the German patent system and civil procedure is. So these are small building blocks that where we are still waiting for guidance from the court, which is probably why the UPC will take some time to actually get to full speed, so to speak, in terms of case law in particular, because people are waiting. People are maybe bringing smaller cases to the UPC and keeping the big cases as backup in the well-tested national systems. Thank you for this.
On you, Nicholas, one exciting thing about UPC might be that they really want to render the decisions within 1 year, which would be very nice to have early clarity. Being advantages or not is another case, but having a clarity early on would be advantageous, of course. But it also creates, as Nicholas mentioned, a lot of pressure on the attorneys, because the deadlines, as he has shown in the procedures, are very short. So that may create pressure, and yeah.
Yes, and we have another question from Priscilla. Do you know whether any injunctions have already been granted by the UPC?
We do not know. There has been some public disclosure by one company that they have filed 2 cases of preliminary injunctions at the EPUPC, but there has been no disclosure whether these injunctions have been granted or rejected, or whether they are still pending. In the system, we can see that there are some orders published, although we cannot access the actual orders, what they contain, but they do not seem to be substantive orders. So I would guess that there have been no injunctions, or not even preliminary injunctions, yet granted by the UPC, but I can't be certain.
Should I skip to the other question from Vihan Dang? Are the judges of the UPC domain experts or generally trained in law without any specific specialization?
Experts. maybe if I start answering you. Well, that's a good question. They actually have a training process, and there is a UPC training a base in Budapest, interestingly enough. And so they do some training to actually get to a standard level, so to speak, and to a unified practice, and that of course will grow over time. But right now we have a lot of judges from the national level, so they are well qualified, of course, but they are trained in different jurisdictions. So that's an interesting mix. And also on the language level, very interesting situation, because you sometimes may have chambers constituted of judges that don't speak the language, at least not like fluently, that is then being spoken in the national court, for example, because they are always mixed chambers. They have local judges, they have judges from the local area, but they also have judges from other member states. So that is going to be interesting. And many chambers have adopted English, for example, as a second language of practice, but not all have. So yeah, well, we'll see. We'll see how they establish a general practice and resolve these issues.
Thank you. And Jerry, there's anything to add from your side?
Oh, I think Nicholas covered it all. We will have multinational panels of judges. As I mentioned, it remains to be seen how they will take their own national case law to the cases, and how would they will decide. We will have technically qualified judges as well. So, yeah.
Thank you very much, Nicholas and Jerry. If anyone has any further questions, please attend the IP Cafe on SAPs to continue the conversation. And the session is now over. Please note that we now have a quick break until 11 a.m. CEST.
Good day, everyone, and welcome back to the afternoon session of our Young AIPPI Summits. I'm just going to give maybe just another 10 seconds for people to get back into their seats and get settled in for the exciting session that we have ahead. And just really want to thank you first and foremost for staying on with us, for those of you who have been here from the very start when we started this morning. And thank you for those that are joining us just for this afternoon session. Just really thank you for your time today and taking time to be with us, to supporting young members and just learning and sharing with each other. I think I will not be the only one to say that it was a really wonderful morning session that we had, and we got through 2 panel sessions as well as 2 cafes, and so that's exactly what we're going to be doing this afternoon. So I hope you're as excited as I am to journey onwards in the afternoon session. And thank you for those that woke up early to join us today, as well as those who are staying on with us as it's getting a little bit late on this side of the world. So with that, I'm just going to invite the Vice Chair of the Young AIPPI Committee, Samantha, to just continue our hellos and welcomes for today and get us started.
Thank you so much, Debbie. Welcome everyone to joining us in the afternoon session. And we are very glad to have the presence of Mr. Soichi Okuyama, the President of AIPPI with us, and also Ms. Annie Choi, the Secretary General of AIPPI with us, and also Judith, the Executive Director of AIPPI. Welcome. Joining us and your amazing support to us. We're also gladly joined by our fellow members of the committee, Dr. Nicholas Kajek and also Jae-won Yoon. Thank you so much, and they will both also be our moderators of our 2 sessions in a bit. So thank you so much all again for joining, and I'm so glad to see some of you also joining us back from the morning session. Hope you guys all enjoyed, and we are now followed by 2 other very exciting topics. And without further ado, I would like to invite Ms. Annie Choi, the Secretary General of AIPPI, to share her opening remarks with us. Thank you so much, Annie.
Thank you, Samantha and Debbie. Good afternoon, members and friends. Welcome and welcome back to the afternoon sessions of the Young AIPPI Summit. Now, I have already said hello to some of you this morning, and please bear with me if you have already heard what I'm about to say to those who have just joined today's program. It is an absolute pleasure to welcome you all to this summit. And through this event, we gather to empower and learn from future leaders of our IP community. Your presence here is a testament to your commitment to personal growth. I'm truly excited to witness the incredible possibilities that will arise from your participation in this event. Now, over the course of the next few hours, as Samantha and Debbie mentioned, there will be 2 more sessions, and also at the AIPPI Cafe, you will engage with the diverse community of young IP professionals, create new connections, and gain valuable insights into the world of IP. I encourage you to embrace this opportunity with enthusiasm and an open mind. Do stay in touch with the connections that you're going to make today, and hopefully you will see each other again very soon in person in Istanbul this October, where our World Congress will be held. Now, once again, thank you, our Young AIPPI committee, who have spent a lot of time putting this event together. So I hope you will all enjoy this afternoon. Thank you.
Thank you so much, Annie. As similar to this morning, I'd like to maybe mention a few housekeeping before we start the session. So this event, want to remind all of you, it will be recorded and will also be made available on the AIPPI YouTube channel. So do visit it if you want to revisit some of the content. During the presentations, we invite all of you to please mute yourself. And if you have any questions to the speakers, please do submit it in the chat box, and these will be raised during the Q&A sessions. And if you have any technical problems, please do send a message using the chat box to the AIPPI events team. Some of the slides used today will be made available upon request, so do send us an email to the events@aippi.org. And also want to remind you, as you lead into the IP Cafe sessions, which are the roundtable sessions, we also invite you all to please turn on your cameras so that you can have and enjoy a great interactive session with your fellow young AIPPI members. So now I will turn the stage to Dr. Nicholas Kajak, who will be moderating the upcoming session for us. So the session 3 today is on e-commerce online marketplace, potential IP liabilities and personal data issues in cross-border transfers. So over to you, Nicholas. Thank you.
Thank you, Samantha. Thank you, Annie, and thank you everyone for joining again and taking part in this great session. Without further ado, I would like to introduce our wonderful speakers for today's session. We have on the one hand, Fiona Chang, who is an attorney at law and partner of the trademark department of Kangxing Partners, a Chinese firm. And she specializes in IP law with a particular focus on trademark prosecution, domain name dispute resolution, IP transactions and licensing, copyright protection, customs protection, and similar matters. She's a qualified IP expert at the CNIPA and the researcher at the well-known Trademark Recognition Committee of the CNIPA, along with the China Jurisprudence Office, and a member of many other organizations, including Interbulletin, AIPPI, China Trademark Association, China Anti-Infringement and Anti-Counterfeiting Alliance, and so forth. And she also frequently publishes on the topic today and related topics. Our next speaker will be Umay Özmen, who is an attorney in the IP and technology practice at Eason Attorney Partnership, a member of Baker McKenzie International. She also specializes on IP law more generally and has a focus on transactional, non-transactional litigation matters in the trademark law, design law, copyright law, internet law, and domain name management. She keeps a close track on the recent developments and updates in IP-driven issues arising from operations of e-commerce platforms in Turkey, both in domestic but also cross-border context. And finally, I'm happy to introduce Andy Yu. Andy's senior associate at Deacons, specializing in IP and data-related work in China. Since the implementation of the PRC, Personal Information Protection Law, Andy has been helping a lot of multinational companies on the China data compliance work, especially involving cross-border data transfer issues, whether in e-commerce context or for group companies' internal administrative purposes. And he also regularly advises his clients in negotiating data processing agreements and different types of IP/IT agreements involving data protection issues. And he has a client base that spans across different sectors, luxury goods, real estate, healthcare, insurance, and asset management, and of course, technology companies. So without further ado, we're looking forward to your presentation and ask you to kindly take over.
Okay, thank you, Nicholas, for the brief introduction about us. So basically, first, I'm going to talk about the counterfeit problem in Turkey with regards to e-commerce platforms, both at domestic and international level. And then Fiona will continue with the situation in China. So starting with my presentation, I want to just give a background information on the counterfeiting problem in Turkey. First of all, production and sales of counterfeit products in Turkey, both at domestic and international level, increases. Even though there can be a lot of reasons for such increase, the most eye-catching reasons for such increase can be rising inflation and decreasing affordability accordingly. And these two factors basically push the consumers to have a demand for those kind of products, which also trigger the supply for those counterfeit products at the producer's end. Next slide, please. So when we look at the effects, the consequences of such increase at the cross-border level, I wanted to share a brief part of OECD report on the current situation. And the counterfeit products which are shipped from Turkey include some clothing stuff, some leather stuff, electronic stuff, and perfumery, luxury, accessories, everything you can think of actually. And in fact, the counterfeit problem in Turkey is something significant because Turkey is one of the major countries through which counterfeit products are shipped to European Union borders. So this is an international problem that Turkey needs to address in a serious extent. Next slide, please. And I also want to give a brief introduction on the role that e-commerce platforms play in terms of sales of counterfeit products to worldwide. As all of we know, e-commerce platforms introduce some kind of facilities in terms of the trade works in our lives. For instance, there is a worldwide consumer and supplier network. Also, there are some practical facilities during pre-sales periods, which encapsulates, for instance, storage or packaging of the products. Also, there are some logistic facilities in terms of distribution of products. So these kind of facilities actually made e-commerce platforms a very preferable choice for distribution of counterfeit products worldwide. Next slide, please. And also, I want to give a factual information about the seriousness of the situation of counterfeit products in which Turkey plays a major role in, unfortunately. And when we look at the social media platforms, we see that there are some advertisements for e-commerce marketplaces who sell counterfeit products worldwide. And also, we see some accounts on social media platforms which are accessible throughout the world. And we see some comments made by people living in the European countries, and they are discussing upon where to buy the best quality counterfeit products from Turkey. So this is something that portrays the seriousness of the problem that I've been talking about. Next slide, please. After this factual information, I want to proceed with giving some legal framework on the current situation. Previous legal framework concerning the position of counterfeiters and e-commerce platforms were not really strict, even though there are some now positive amendments to the current situation. E-commerce platforms previously and still they are regarded as hosting providers. And with regards to counterfeit products and their distribution, e-commerce platforms were not obliged to monitor the content. Therefore, they were not obliged to remove the content if the content is relating to a counterfeit product which infringes on a trademark right, for instance. Next slide, please. So now I want to talk about some positive amendments with respect to the position that e-commerce platforms are now in. As of January 1st, 2023, law on amendments in the e-commerce law enter into the force. And with these amendments, there is a recently introduced takedown mechanism for IP right infringements, which also encapsulate counterfeit products as well. Basically, e-commerce law brings about an umbrella protection and draws a umbrella provision about the takedown mechanism. Basically, the mechanism works like this. If an IP right holder, even though the IP right is an industrial property right or intellectual property right, notices that there is an infringement of the IP right through a content that is being hosted on an e-commerce platform, which may be a counterfeit product, then the relevant right holder may file a takedown request to the relevant e-commerce platform and request taking down of the content that was in the dispute. And the relevant e-commerce platform is required to respond to the request within 48 hours, which is a very brief time period. And along with this request, also, the relevant right holder is required to submit some kind of documentation and information, which I will be discussing in the next section. And finally, as of January 1st, 2023, e-commerce regulation was also published and entered into force. E-commerce regulation draws a very broad scope of the takedown mechanism that I've been talking about. So this regulation brings about some kind of, details and elaborations on the mechanism. Next slide, please. As I told you before, the right holder who wants to file a takedown request because of a counterfeit product being sold through an e-commerce platform needs to submit some documentation and information. I believe we can subcategorize these documentation and information under 3 subcategories. The first category comprises of a registration certificate, which is issued by the Turkish Patent and Trademark Office. Or if we are talking about the copyrighted material, then a banderol form issued by Ministry of Culture and Tourism. Secondly, the relevant right holder who wants to file a takedown request needs to give the information about their address, their name or business title, as well as the disputed website content. And finally, as the third subcategory, the right holder needs to submit some evidence that the disputed products infringes on their IP rights, which may be, again, an industrial property right or intellectual property right. And upon filing this kind of a takedown request, e-commerce platforms have to entertain such claim and review all of the materials and documentation within 48 hours, and then remove the content. After removal of the content provider, which is in our case the supplier of those products, are entitled to object such decision. Next slide, please. Even though I talked about some positive amendments with regards to sales of counterfeit products through e-commerce platforms at both domestic and international level, unfortunately, the execution of these e-commerce law and e-commerce regulation is kind of vague, unclear, and ambiguous. It's because of the situation that some articles in the e-commerce law are currently being examined by the Turkish Constitutional Court. And accordingly, the State Council of Turkey suspended execution of e-commerce regulation, including the articles which are about the takedown mechanism that I've been talking about. So even though we see some positive amendments regarding the situation, the execution of the relevant provisions is really unclear and ambiguous for now. Next slide, please. As the final part of my presentation, I want to give some brief introduction about the ongoing problems, despite the positive amendments that I've been talking about, and some strategic advice. First of all, even though there are some positive amendments envisaged in the Turkish legal system, there is a lack of permanency, because even though takedown mechanism in fact works as a mechanism to prevent counterfeiters to sell their products for a while, usually in Turkey, these counterfeiters are working very systematically. And if they receive a takedown request, then they are just opening a new account and they're selling the same counterfeit products along with different titles or along with different descriptions. So this is something temporary, but there is a lack of permanency, which would totally discourage those counterfeiters from producing and selling those goods. And secondly, there is a lack of special provisions in cross-border trade, because all of the things that I mentioned so far is applicable both at international sales through e-commerce platforms as well as the domestic ones. And when we talk about the current situation that Turkey is in, which I gave some factual background on the seriousity of the problem, there needs to be some strict rules with regards to some criminal penalties or administrative fines, which would definitely discourage those counterfeiters from selling these products abroad and limit the level of and volume of those products that are being distributed worldwide. And there is a problematic side of requested documents. As I said, as the first subcategory of the documents that are requested for filing a takedown request, I said that there needs to be a registration certificate issued by the Turkish Patent and Trademark Office if we are talking about an industrial property right. Or if we are talking about a copyright, then a banderol form, which is issued by Ministry of Culture and Tourism, should be submitted. However, in most of the cases, we talk about some global firms, and these global firms may not necessarily have a registered, for instance, trademark before the Turkish Patent and Trademark Office, and the trademark may be infringed upon by a counterfeiter in terms of using and selling and producing those kind of counterfeit products. So unfortunately, this kind of a global firm will not be able to submit a registration certificate from the local authority. So there are some problematic sides of the requested documents which should be widened. And finally, there is a problematic side of evidencing infringement, because as I said, as the third subcategory, the right holder needs to prove that there is an infringement upon their IP rights. And unfortunately, the regulation is silent about which kind of documentation, which kind of information, or maybe photos, videos, or etc. should be submitted to prove that there is unfortunately an infringing act. So this kind of the scope of this regulation should be more specified. And basically, these were the things that I wanted to tell you within 15 minutes. And Fiona will now continue with the situation in China. Thank you so much for listening to me.
Thank you so much for the introduction from Nicholas and Yume. And hello, everyone. Thank you so much for your time. And I'm so honored to be here to share some information along with strategies for cross-border e-commerce business in China. And first of all, I will show you some data about the cross-border e-commerce in China and to show the developments in Chinese markets during the passing years. And from the first chart, and we can see that the sales volume is continuously going up, even under the affection of COVID-19 in China. And until 2021, and the volume of transaction of the cross-border e-commerce business produced a quadruple than the amount in 2013. And for the second chart, and we can say that amongst the total transaction volume, the part of exportation makes up triple in size from the importation parts. And it seems that the Chinese products are becoming popular in many international e-commerce platforms. And based on the survey report published by Amazon, and we can see that there are more than 200 sellers from China and Hong Kong, which occupied over 60% as compared to other participants or sellers. And let's move on to the next. And we will show some, the new trends in Chinese markets. And in 2022, even most of the cities are still in lockdown due to the COVID-19 in China. And we have seen that the government issued many policies encouraging the Chinese companies going out. In some south cities, the government or business office are working on the contact of business with some companies outside of China. In addition, with the booming development of e-commerce in Chinese markets, there are more and more famous internet or technology companies entering in. And you can see that including but not limited to Alibaba, Pinduoduo, or ByteDance. And after the Amazon event occurred in 2021, more and more companies focus on the legal compliance management, especially when they start the global trade business at the beginning. And although there are still some restrictions and challenges for Chinese participants with implementing the compliance and brand management process, they are starting to try to find some various solutions, such as do the DTC. And next, we will see some typical, the blitz points of the IP problems in China. And in this part, I just list some outline of the IP problems, but in order to show the details, I will show you some typical cases in China. And let's move on to the first case. Yes, and for the Shein case, and as you may know that Shein is coming from a small city in Guangzhou and working for fashionable business, including clothing, cosmetics, or fancy associations, and relying on the quick response speed on the manufacturing. They could do the sample dresses within 1 or 2 business days, and then could customize the designs to meet the requirements of the customers. This is also the secret that Shein could lead up to one of the famous brands, especially in the overseas markets within a short time. But also Shein has achieved the great management in the markets, and we can see from the next slide to see the IP problems of Shein in overseas markets. And yes, and we can see from the left the map. And you know that the map also indicates that Shein has filed many trademark filings, even the trademark registrations in many in many target markets, including America, Europe, Asia, and Australia, and so on. But this still cannot prevent them from the splitter from the rush registering, even copying their designs or products. And I trust that this is not an individual case because it usually happens, and it may be a common troublesome problems for many brand holders. But how to end up is that is a difficult question for all of us. But before answering that, let's see another typical case for the next. Yes. And for the Amazon event in 2021. And I have already mentioned some minutes ago that was late, and we can see that Amazon has issued many new regulations in 2021. And based on this, there are more than 600 Chinese brands and over 1,000 companies involved in. With the banning policy of Amazon, more than 50,000 accounts were frozen, which lead to millions of US dollars lost directly. And the reason that Amazon indicated that the outside companies alleged violations, including manipulating comments, collecting farming, and associating accounts improperly, and so on. And this is really serious and affects many attitude of the Chinese customers or the sellers on the e-commerce platform. And we can also set a question here, and so we may just say the last case for the Squid Game. And yes, and I trust that you must have seen the movie through the internet, right? And actually, this is exactly a popular Korean movie named Squid Game. And after it was released in China, and the relative characters, music, clothing, even the game props will quickly become the hot cake. and widely discussed by the customers. And with following the trends, there are many sellers and the manufacturing companies working on that and put them to be sold on the e-commerce platform. But with the intense legal actions initiated by the agency of the holder, there were plenty of products required to be taken down. And from these three typical cases, and we can see that the key IP problems are the scratching or the land violations and together with the copying or something like that. But in order to support the development of cross-border, let's say some regulations and policies issued by the government in the next. And I just list some particular regulations here in China, but actually the regulations or policies together with guidance are a huge amount to be implemented in China. And amongst of them, I really wish to share some details about the guidance issued by the China IP office in the next slide, please. And yes, and in this part, we can see that the office has strongly recommended many suggestions, not only for the participants or sellers, but also for the platform providers. And first, we can say something about the participants or sellers. On the next slide, please. Yes, here. And for the participants or sellers, the office strongly recommends to reinforce the position of IP protection at the beginning, including but not limited to tailor the long-term and perspective brand management plan, and to be more familiar with the local laws or regulations, and do the customer regulations or obtain the professional legal evaluation before exploring the overseas markets. And apart from establishing the strong modes as events, the office also suggests conducting the regular watching and the monitoring for the marketing infringements, and also reminds the participants to standardize the use minors in order to lower the risk of infringements. And the part in small both are just some details, and we may first move on to the next to see some obligations for the platform providers. And here we can see that the office also sets up many obligations and standards for e-commerce platform providers, similar to Amazon. And the most popular domestic platforms also adopt the similar complaints and lawsuit procedure in China in order to have some foreign companies do business in China. And most of the e-commerce platform could provide 7-day examination procedure with the similar requirements adopted by Amazon, especially for the evidence required documentation together with the legal process and so on. And sometimes for some special cases, the examination could be shortened to 3 days, which is really efficient. And such is benefits from the standards and the guidance issued by the trademark office. And to be particular, the office also requires timely publication and the tracing obligation to make the process more clearer and more transparent. And assuming that the platform cannot fulfill the obligations, the office, together with the local business office, will perform the investigation and decide to punish the platform providers or have the customers include the platform providers as the joint defendants in litigation for the finance compensation. And next, we will see some also the details about the regulations and the guidance. And next, we will see that, yes, and returning back to the typical cases that I have already mentioned, and let's say some tips and suggestions for some for the resolutions. And here we can see that it's really advisable to make the proactive and prospective brand management strategy at the beginning, even before they are expanding the overseas markets. And after that, we should really remain to standardize the use minors and be more familiar with the local laws or the regulations, together with the examination attitudes about the other or the target countries or areas, and also do the good monitoring and watching system. And the other important thing is to establish the evidence database, and in order to actively react against the lawsuits or the infringement attacks from others. And next, we will, and in this part, given that most of the things have already been shared, but in this part, I just want to emphasize the duplicate application strategy. And even in China, based on the new trademark law, it's really a good strategy for most of the participants to file the applications in order to lower the risk of non-use cancellation attacks from others. And next is also the important thing in the next slide, please. Yes, here. And another important thing is respecting the IP rights with both the China customers together with other countries or areas in order to seek the customer support to monitor the marketing competitors and stop the companies going out and limit the battlegrounds as a first step. And the last page is one of the screenshots is for our marketing watching and monitoring services in order to try to figure out some suspected infringers by tracing the case word, picture, or the name, and so on. And with analyzing the watching results by AI technology, it will be much easier and more accurate to fix the suspected infringers, which will also keep our legal actions more particular and specialized. And well, that brings my part to the end. And next, please allow me to introduce my teammate, Andy, to share with something about the data transfer in China.
Thank you, Yume and Fiona, for their insightful sharing. And also thank you, Nicholas, for his earlier introduction. So next, I'm going to talk about the personal data issues, especially from the PRC context in a cross-border e-commerce business context. So as you may know, China has recently implemented the Personal Information Protection Law, the so-called PIPL, in 2021. And this is the first comprehensive personal data protection law in China. And because of its resemblance with the EU GDPR, some of the practitioners or business owners have referred the PIPL as the Chinese version of the GDPR. So the first question you may ask is why is the PIPL relevant in the cross-border e-commerce context? It is relevant because it regulates the outbound transfer of personal data collected in China to all other jurisdictions, including Hong Kong, Macau, and Taiwan. So if a foreign company receives personal data transferred from China, the PIPL may be relevant to you. And over the past year, we have seen that the Chinese regulators have released a number of updates about the practical requirements to facilitate the outbound transfer of personal data. And one of these key requirements is to adopt a transfer tool. So you can see from the slide here that there are three transfer tools available under the PIPL. First is to pass an official assessment conducted by the Chinese regulator, commonly known as the CAC. Secondly, is for the Chinese entity and the overseas recipients receiving the data to enter into a standard contract and record the contract with the CAC. Lastly, there's also a transfer tool available for obtaining a certification from an organization designated by the CAC. So you can imagine that there are different criteria for adopting this transfer tool. And I'm not going into the details because of the time constraint. But you can imagine that passing an official security assessment is much more complicated and difficult compared to, for example, recording a standard contract with the regulator. However, it is worth noting that not all personal data handlers are qualified to adopt a standard contract as a transfer tool, and it really depends on the volume and the types of personal data involved. That being said, in our discussion of our hypothetical examples today, we are going to focus mainly on the use of standard contract as a transfer tool and also its implications to the overseas recipients. So our next question is, since the obligations to comply to facilitate the outbound transfer is on the personal data normally located within China, why does it at all concern the foreign or overseas companies, being only the overseas recipients receiving such data? And I'm going to answer this question using several common scenarios that we may encounter in the e-commerce cross-border e-commerce context as an illustration. Now, in our scenario 1, we are essentially talking about an intra-group transfer situation. Now, let's assume that your company is based in the United States and that this US company also owns a Chinese company which is operating a .cn website or a mobile applications host within China. And then this company is also running a global loyalty program which offers your customers worldwide privileges when they travel abroad and use your products and services around the world outside China. In order to do that, your Chinese company will have to transfer the personal data they collected within China to other companies around the world, including your headquarters in the United States. And you may recall from my introduction that this kind of data flow is indeed regulated under the PIPL. If such outbound data transfer is not compliant and therefore prohibited by the regulator, then the practical implication is that all of your foreign companies, including your headquarters companies in the States, will not be able to receive the personal data of the Chinese consumers. It also follows that you may not be able to provide them with the global products and services as planned. So under this scenario, it is important for you to adopt a holistic approach in first determining the transfer tool applicable to your Chinese entity in order to facilitate the outbound transfer. Now, let's assume that your Chinese entity is eligible for adopting the standard contract as just mentioned because the volume of transfer does not meet the prescribed threshold. So what do you need to be aware of as an overseas company from a contractual perspective? First of all, the contents of the standard contract cannot be modified. However, you may feel free to include additional contents into the contract, but such contents should not be in conflict or override the standard contractual clauses. Now, a related question is therefore whether or not the overseas company are able to fulfill all the obligations imposed under the standard contract. For example, you may need to consider questions such as whether the overseas companies are subject to any confidentiality obligations vis-a-vis other parties in other separate contractual relationship. Secondly, the standard contract is drafted from the Chinese regulator's perspective, and it may not be sufficient to address all other commercial or other business arrangements among the contractual parties. So going back to the example that we're talking about now, say if your Chinese entity is going to transfer the personal data of the Chinese consumers to 20 other foreign global entities around the world, which may use the data for different purposes, then one key question that you may need to address is whether or not you need to make further delineation as to each other's rights, obligations, as well as their corresponding liabilities into the standard contract clause. Now let's move on to the next scenario, scenario 2. In this scenario, the data flow, you can see that it's essentially the same as scenario 1, but the major difference is that the first touch point in collecting the personal data of the Chinese consumers in China is an unrelated local Chinese business partner or distributor operating their own .cn website or mobile applications. Now, the considerations here are pretty much different because, as just mentioned, the obligations to adopt and also to comply with the transfer tool is on the local entity. And in this scenario, the local distributor or the business partner. However, as just mentioned, since this distributor or partner is not within your group, you may not have full visibility as to the data compliance level of such Chinese entity. And therefore, it is crucial that you have to rely on other methods to manage the risk of receiving such data, such as conducting a due diligence on the source of the data to be transferred, as well as adding relevant contractual terms to protect the legal position of the overseas company. So back to our example. Now, let's assume that your Chinese distributor is proposing to enter into a standard contract with your overseas company in order to facilitate the transfer. In order to protect the interest of your overseas entity, you may wish to ask for some contractual clauses to protect your interests, such as a warranty, confirming that it is eligible to adopt the standard contract as a transfer tool. And you may also consider to the extent that the Chinese entity is no longer eligible to adopt the standard contract. Say, for example, the volume of the data that they intend to transfer is too substantial that they cannot rely on the standard contract. Then, are there any exit arrangements placed under the contract? These are some key issues that you may need to consider. Another related issue that foreign companies should consider is whether the data transfer governed by the intended to be governed by the standard contract is subject to the terms in other main contracts, such as the distribution agreement or cooperation agreements between the parties. For example, your overseas entity would ideally hope that your certain clauses in the distribution agreement, which may not be favorable to you, such as the limitation of liability, does not necessarily apply to also the data transfer in question. Now, let's move on to the last scenario. Because of time constraint, I'm not going to talk about the details of this scenario, but I just wanted to point out that in this scenario, the idea is that a foreign company is operating a website hosted outside China. And through this website, this company is directly collecting and processing personal data of consumers within China, say, for example, by for the purpose of providing them with goods and services outside China, or to analyze their behavior. Then I just wanted to mention that the PIPL has extraterritorial applicability. And in that case, in this scenario, the PIPL may also apply to the foreign company, even though they may not have any local entity or local partner or distributor in China collecting the data for them. So before we wrap up this session, here are some fruitful thoughts and some preliminary questions for you to quickly determine whether or not the PIPL is at all relevant to your business, so that you may need to make relevant legal, contractual, and compliance consideration in your daily work. First of all, a key question that you should ask is, why do you really need to receive personal data collected in China? Whether you are receiving such data from your local wholly owned entity, or whether you are receiving the data from a unrelated local Chinese partner or distributor. We are asking this question because given the more stringent regulation of the outbound transfer under the PIPL in light of the recent updates, the game plan should no longer be the more the better, even though obviously from a business perspective, you would like to receive more data in order to exploit and also to look for more commercial opportunities. But given the more stringent compliance requirements in light of the recent updates, the game plan should no longer be the more the better. And even if you do need to receive personal data from China, the next question you should consider is, what are the necessary types of personal data required to be transferred for your purpose? Since the transfer must be justified with business needs, you should really only collect and transfer and receive the necessary types of personal data subject to the protection and the regulation of the PIPL. Moreover, you also need to consider what is your role as an overseas recipient in the data transfer scenarios. So you may recall that we talked about 3 scenarios just now. In the first scenario, you may wish to really ask, is the data transfer essentially an intragroup transfer? And in the second scenario, is the data transfer part of an arm's length transaction with your local partners or distributors in China? And thirdly, Is your overseas entity directly collecting and processing personal data of consumers within China, even though your website is hosted outside China, and that you do not receive any data directly from any local Chinese entity? And depending on which scenario applies to you, the overall game plan and the considerations from a legal and contractual perspective will be different, as just discussed. So that's all for my part, and thank you so much for joining our session. And I'll now maybe pass on the stage back to our moderator, Nicholas, for the Q&A session.
Thank you, Andy. Thank you, Uma and Fiona, for your great presentations. We now have sufficient time for questions from the audience. I already have a couple of questions of my own, but maybe we can give the audience the advantage of proposing some questions first. Do we have anyone with any questions relating to, for example, situation in China, GDPR, or trademark infringement, similar matters? If not, then I would simply go on. Something that came up during, I think it was Fiona's presentation actually, was the question or the statement that AI is actually already used to find out patent infringement. I just wanted to ask the three of you if you noticed use of AI, if you already use AI by yourselves in your daily practice when dealing with e-commerce issues, cross-border or not.
Actually, yes, and in China, and there are many technology companies are working on research for AI technology in many business fields, and in our IP fields, and we also launched our own platform, and on that we can show something about the including some marketplace to do the search or watching or monitoring regularly by AI, and given that AI technology will make things much easier and to much accurate to fix the infringers or something like that. So we, apart from the infringement watching or monitoring, we also use AI technology to check the trademark similarities or do the trademark search or something like that in China. Yes.
And Uma and Andy, do you have any use cases of AI already in your practice, or do you mostly refer to the legal handiwork?
Unfortunately, for infringement parts, in my professional experience, I've never used any AI. But as Fiona mentioned, when we look at some similar trademarks, which are like similar to our clients' marks, we are benefiting from AI sources, which very facilitates for us and which very eliminates the volume of the paperwork that we have to deal with. But in terms of infringement, I wish that there will be some kind of an AI tool, but unfortunately, there are not.
And GDPR related, do you think there's use cases for that as well, Andy?
Well, I think, yeah, it is a Chinese version of GDPR, but it's not exactly a GDPR. But in terms of, in terms of the use of AI tools, I think it really depends, because after all, like I just mentioned, the PIPL is very newly implemented, and in our real life practice, when we liaise with the some of the regulators and also the examiners, I think that they are also still trying to figure out what their examination standard is and what their enforcement standard is in terms of the data protection issues. So I think it takes time for, even if we are going to, for AI tools to be adopted to, facilitate some compliance and also contractual work. But I think it takes time for them to, after all, AI has to learn, they also have to, learn from the examiners. And I think, first of all, we need to really understand how the examination standard is going to be set in terms of the enforcement and compliance work.
And are there any special requirements in the PIPL compared, for example, to the GDPR? For data
well, I would say
protection?
that, yes, I would say that, like I just mentioned, if you're not too familiar with the data protection work, I would say that they do have similar concepts and framework from what I've just introduced. And well, basically, a key issue that they are going to regulate is to govern and to restrict the outbound data flow and the data transfer outside their jurisdiction. But I would say that a key difference is that because some of our clients are also asking, hey, I'm already GDPR compliant. Do I need to, do our PIPL review, or do we need to consider PIPL issues? Obviously, the answer is yes, because first of all, they regulate different data flow. For GDPR, we are talking about data transfer outside EU, and for PIPL, we are talking about data transfer outside China. So the PIPL framework does not, at all address the opposite data flow at all, and they are only talking about, and they only concerns the data flow transfer outside China. And in terms of the transfer tool, as you can just imagine, the transfer tool available under the PIPL is more limited because, in GDPR, we can see that there are concepts like adequate decision, and there are also binding corporate rules available for, as part of the transfer tool to facilitate the transfer. But we don't have similar concepts in China in the PIPL. Obviously, it could change. Some seminars, some speakers from the regulators have mentioned that they could explore expanding the transfer tool. But like I just mentioned, currently under the PIPL framework, they are just a free limited transfer tool. And if you cannot, for example, rely on the less stringent standard contract to facilitate the data transfer, then most likely you are going to go for the hard route, which is the official assessment, which is a much more complicated process in order to pass the regulators' scrutiny. So there's a brief, explanation about the difference between the PIPL and the GDPR.
Okay, well, thank you, Andy. There's actually a question from our President Debbie, and she's asking, looking towards the future, what is one thing that you would want to see done better or more efficient, both from perspective of the borderless online marketplaces and the flow of data? I think that's actually a question for all of you, particularly maybe Umay and Fiona, but also Andy.
Okay, and first in China, given that squatters or the behavior for the rush register is also important and much troublesome. So I think that in the future, we should figure out a good way to help the trademark holders or the IP right holders to protect their own IP rights efficiently and strongly. Yes, this is the most things that I think in China, which is also a big problem in China, in Chinese markets. Yeah. Thank you.
And Umay, what's your opinion on that?
In fact, I briefly talk about this kind of a question during my presentation. First of all, in terms of some potential future IP-related liabilities, I believe that there is a disadvantageous position in terms of global firms who are producing some, branded products, for instance, because as I said, the current regulation and the current law only introduces some temporary actions, and they are not really in terms of efficiency and in terms of solution based, they are not very adequate. And also, as I said, the regulation is kind of written in terms of the right holders who are residing in Turkey. So when we talk about the global firm who has a brand and who is producing some variety of the goods worldwide. And when we see a counterfeit product from a Turkish supplier, then in terms of the documentation that needs to be submitted by the global firm, and in terms of tracking the whole takedown process, it's something difficult for the part of global firms. So I think there should be more precise and more strict rules regarding cross-border trade and with regards to the global firms who are as the position of IP right holders. So basically, these are my notes about the question.
All right, Andy, anything to add? Oh, there's actually another question, but we'll have to check because I think we're getting into the few minutes break. Do we still have some time for this question? Samantha, Debbie, yeah? Then I'll just jump to it. and it's from Vihan Dang, and it's, is there a legal requirement in China or Turkey for an e-commerce platform to have a notice and takedown policy in place for trademark issues counterfeiting infringement similar to DMCA for copyright in the US, or is it just voluntary option?
But in Chinese market, and given that the procedure or process adopted by the domestic e-commerce platform is very similar to Amazon or something like that. So in China, and yes, there is a legal requirements in China, and the procedure or the required documents together with the evidence is really similar to Amazon. So it's really helpful and good for foreign companies to do the e-commerce in China with the same or similar principle.
And finally, in Turkey, Umay?
So when we talk about the situation in Turkey, as I briefly mentioned about my presentation, first of all, along with the newly introduced amendments to the e-commerce law and e-commerce regulation, now e-commerce platforms are required to take down the specific content if they receive any kind of notice or cease and desist letter or any notice with along with their internal reporting system. If the content is infringing upon their IP rights, which also encapsulates sales of counterfeit products. And the e-commerce platforms have to oblige those requests if the relevant right holders are able to submit the relevant documentation and information that they are the IP right holder of a specific brand, for instance. And apart from that, the content provider, which is in our case, basically the supplier of counterfeit products, are also entitled to file an objection against this takedown mechanism if the relevant content is taken down. And apart from that, of course, there are some litigious solutions to the problem. But the main point is that e-commerce law and e-commerce regulation brings about a very fast and very temporarily solution to the ongoing problem, because counterfeit products is something very common in Turkey and they need to be addressed in a very quick way. So in this way, the takedown mechanism that e-commerce law and regulation introduced is something very good. But as I said, apart from that, which is something recently introduced change in our legal system, there are also some litigational ways, of course. So basically, these are my notes about the question. Thank you.
Okay, thank you so much, all of you. I think we're already at our time limit, maybe a little bit past it even. So I'm happy to hand over back to Samantha and Debbie and everyone who will join us for the next session.
Thank you very much, Nicholas. Thank you so much for a wonderful session on e-commerce and data privacy. Thank you so much for Nicholas and Fiona, Umay, and Andy. So a great discussion and great Q&A session. So now we are heading to the time for our next session, which is session 4. On where is the metaverse heading to, the latest developments in IP issues in the virtual worlds. So thank you so much for Jay Won, also a member of the YAC who will moderate this session. Thank you so much for taking us into a topic that has been widely discussed last year, and now we want to understand where metaverse is heading to. Over to you, Jay Won. Thank you. Muted.
Sorry.
Thank you, Jaewon. Yes.
Yeah,
perfect.
thank you, Samantha. I'm thrilled to be a moderator for these sessions. And as Samantha mentions, we will cover the topic, where is the metaverse heading to, and the latest developments of IP issues in the virtual world. So we have 2 speakers. Our first speaker is Ms. Anastasia Skopban, and Anna is an IP lawyer at Nestle LLM, Russia and Eurasia. She is majoring in trademark copyright protections and transactions in the fast-moving consumer goods and IT industries. She was ranked in 2021 in the intellectual property law and litigation sections of Best Lawyers magazines. and also ranked as a rising star of the Legal 500 in 2021. Anna, as an in-house counsel, she will share her view of legal issue that companies can face in the metaverse and what should be considered while implementing metaverse experience for the consumers. And our second speaker is Ms. Uche Isonu. Uche is an associate in the IP team at Clifford Chance LLP London. She has advised on a wide range of matters, including trademark, software, patent disputes, sponsorship agreements in the sporting and media industry, marketing law, and the IP aspects of due diligence for private equity and M&As. Uche has a particular interest in fashion, beauty, media, and sporting industry. She supports the provision of ongoing trademark litigation advice to the global cosmetic company and has written thought leadership pieces in relationship to the fashions and luxurious brand industry. So today, Uche will talk especially about branding and fashion consideration in the metaverse. So let's give a warm welcome to our first speaker, Anna. Anna, you may take the floor now. Unmute.
Thank you so much, Yvonne, for introduction and your moderation, obviously. And I'm thrilled to be here. And today we will discuss metaverse. What does it mean? And how it might change intellectual property or not. I focus on metaverse as a new technology and a platform for content sharing. The difficulty is that we may have when we try to distinguish who owns what, and most importantly, how brands may protect themselves. So metaverse, what does it mean? Metaverse, according to Merriam-Webster dictionary, a persistent virtual environment that allows us basically access to and interoperability of multiple individual virtual realities. So from that definition, we may isolate the key competitive features of metaverse: virtual and real time. It's not digital. It's not an augmented reality. The sense of working or visiting the metaverse should be the same as you surfing internet, but unlike analog internet, let's say like that, experience instead of little mouse, your avatar who navigates through virtual spaces. Interoperable and interactive. Interactivity in metaverse means I can communicate with others, touch and feel virtual objects, and do something with them by redesign, carry, and transfer. Interoperable means that I can access the metaverse space from different enter points, apps, and devices, and accessible and multiple ways of use. Same applies here. Multiple ways of use means that metaverse isn't just for communication or gaming, which are also important, but for different industries and business models, and my colleague, which will show you how in her presentation. But what is most important, in my opinion, and I do believe that it's quite obvious at the moment, metaverse is not Web3 and not game or gaming experience. As we can see, it's not a Web3, since Web3 is about decentralized interaction and access to the services. Metaverse experience still looks like traditional intermediary model. When the services are provided by identified person who's responsible for the performance of such services. And as I mentioned, metaverse and metaverse platforms, a global market share of metaverse at the moment, or in 2022, quite rich and diverse, from fashion to finance. And we also can see numbers from Fortune Business Insights report. By 2027, the numbers of metaverse market size will be, I think, 10 times bigger from what we have in 2022. It's enormous, and it shows that metaverse itself is quite desirable for industries, for investment, and it's very important to be really careful and knowledgeable about what we work, what metaverse actually means, because why I separate metaverse from the metaverse platforms? Because in great report by McKinsey, Value Creation in the Metaverse, the real business of the virtual world by 2022, metaverse platforms just a part of metaverse, because there are 10 layers of the metaverse and 4 tiers. First tier is enablers, payment and monetization techniques, identity issues, and privacy and confidential information enablers, security, privacy, and governance. Second tier is infrastructure and hardware, very important, because infrastructure, devices, and accessories, this is what we should have to have metaverse experience, because otherwise we don't have metaverse at all. And only on the third tier we have platforms, creators or 3D development platforms, and platforms for access and discovery. And what is most important for us as IP lawyers and people who work with brands, content and experience is the fourth tier of our layers of the metaverse, which include virtual worlds, application, content. So what we usually have to handle, or what we usually have to consider when we work with metaverse, when we work with user-generated content, and when we try to blend it with brand experience, brand intellectual property rights, mostly K visuals, and etc. So as we can see, metaverse is a developing opportunity. Numbers show that we have more daily active users. We have growth in trading volumes, we have growth in investment, but also we have a great opportunity from the technical side, because we have patents and different types of enablers that helps us to be more interoperable in metaverse, which enhance our experience, which provides us with AR/VR device proliferation. But at the same time, there are a lot of major restraints, because, for example, security concerns as data privacy, because we had a great discussion just right here, lack of awareness, and I speak about awareness from consumers, from users, and from brands, and lack of government rules and regulations. And speaking about government rules and regulations, it's not exactly, it's not sounds like we had to regulate metaverse or we need new regulation. No, from my side and from my point of view, we had to understand how we need to apply our existing regulation to metaverse, because as we can see, metaverse still something about service providers. So for example, whether or not DMCA applies to service providers, metaverse platforms, this is a key question. So What about future restraints? Because, you know, we all know that there are a lot of IP issues. We know about data issues, but from my point of view, one of the future restraints that we can foresee is some anti-competitive actions. If one company encompasses devices, platforms, apps, and content for metaverse experience, it can cause tie-in effect and make this company a gatekeeper who writes rules for smaller actors. For example, we all know about Microsoft, the old one. We all know about Apple and Epic Games, great case that I would recommend to read. I do believe that you all know about it. And here we have Google Ads platform that is subject to examination from US and EU authorities. And yes, this is under examination and maybe possible reorganization. So at the moment, we have a lot of majors, big companies, big brands from media, from IT, who wants to be a ruler, who wants to be the first from from metaverse side of view. But at the same time, I do believe they forget about this time effect and these consequences of such aggressive marketing campaigns or such aggressive actions. So let's say we have and we understand what metaverse platform is. So who owns derivative works, who owns what? Because we have metaverse platforms IPR. This is virtual spaces, different toolkits, 3D models, patterns, but virtual spaces sometimes is just, it has nothing. It's just white walls, and sometimes these virtual spaces, pre-created virtual spaces and toolkits could be unprotectable, not copyrightable at all, because it's just simple objects. And sometimes pre-created virtual spaces might be really had a really an artistic influence or be created by very famous, for example, architects. So brands IPR on the other sides is about trademark or trade dress, designs, including designs patterns. So what happens when they try to blend it, use key visuals, trademarks, designs, look and feel of the brand in metaverse, in pre-created virtual spaces, for example, using toolkits and 3D models provided by metaverse platforms. And this is unreadable. True it is, but let's try to understand it. This is terms and conditions of one of the popular platform, Spatial. Spatial provides virtual space metaverse experience, and as you can see, as let's say analog normal service provider, Spatial let's say emphasize that we own our IPRs, we own our platform, our toolkits, our 3D models. Brands own their own IPRs, trademarks, copyrights, patents, and so on and so forth. But at the same time, there are something tricky, because it states that you hereby assign to Spatial, including all intellectual property rights that you may have on acquire anyway in the world, to the service provided or made accessible by Spatial. So this tricky wording might signal that it means that derivative works made from one hand, pre-created virtual spaces and metaverse platforms IPR, and brands own, for example, photos, logos, and so on, might be owned by Spatial, and Spatial metaverse platform might use it even in, for example, advertisement or promotional activities. So this is important when brands start using let's say mass adopted metaverse platforms. They have to be very careful about these, because it's not a good situation when your let's say private or very sensitive IPR works used for promotional activities. And what's the most important, many platforms, many metaverse platforms admit that there are, identified legal entities, and under copyright legislation, they have to be, they abide by DMCA rules. So in case of someone, infringe your right or infringe the rights of particular author, rights owner, brand, DMCA applies. So, and the last one, trademark protection in metaverse. And trademark protection is very tricky, because from one point of view, you don't know what you actually own in metaverse, because it's just a virtual thing. But this virtual thing has their own price and their own value for users, for owners, and that's why trademark protection in metaverse is key. For example, for Nike and the Nike Metaverse experience, Nike created the Swoosh platform that will house all brands' virtual designs and creation. And upon this, Nike filed 3 applications for trademark registration connected to such platform: Nike Swoosh logo, .swoosh at the world, and .swoosh with .itself. So why it is important and why we need to protect our brands in metaverse or in related activities, because we had this perfect example, Hermes International versus Mason Rothschild, the great case that we have in United States, because Hermes believed that Birkin trademark was used in Rothschild's NFT collection and in Metaverse collection in relation to virtual objects that looked like Birkin bag, and it means that these Birkin bags immediately associated with Hermes. And what are Hermes trademarks registered for? For bags and leather goods, not for virtual objects. Anyway, NFTs at Rothschild sells handbag, NFTs that Rothschild sells actually sold, were treated as virtual objects, and Hermes trademarks are well known, so that's why this case were decided in favor of Hermes International. But this is very important. This case started when Hermes International don't have any trademark in relation to any virtual objects or something like that. And after they filed the claim, Hermes filed several trademarks in relation to their brand to protect them in metaverse and in virtual spaces. So it means that there is no way, and it's still a very tricky that your well-known mark might not protect you in metaverse. So it would be better if you try to protect it by filing a trademark application. So how we can do it? We can use these these 4 classes of needs and use something like downloadable virtual goods and retail store services featuring virtual goods and digital tokens or even NFTs. So it might help, but anyways, brands should be very careful when they work or collaborate with modern artists, with metaverse platforms, and they need to understand the potential risks, because metaverse platforms growth is unstoppable, obviously, and brands try to be on the top. So let's say, and let's summarize, metaverse platforms is still identifiable legal entities, and under DMCA they have to delete any infringing content. But brands at the same time must be careful with derivative works they created on metaverse platforms and trademark protection, obviously. So this is all from me. Thank you.
Thanks very much for that, Anna. I'm going to be following on from Anna's brilliant presentation with a focus on the metaverse and branding and fashion considerations within the metaverse. Anna's covered on some of the key cases, but I'm going to be giving a bit of an overview. So I'm going to be looking at why fashion and luxury brands even want to be in the metaverse, and I'm going to use 2 case studies to show some considerations that brands need to think of. So we're going to be looking at co-branding in the metaverse and virtual events in the metaverse. So many people would argue over the past year or so that the metaverse for brands looks like it's kind of been more trouble than good. There's been a lot of litigation, lots of mishaps, lots of launches that haven't necessarily gone that well, but there are many reasons that a brand might want to capitalize on it. So generally, you can really expand your audience reach. Gen Z audiences that previously haven't really shopped luxury brands or different fashion brands may have their first interaction with a luxury brand through a game like Roblox or Fortnite. Improved customer engagement, so you can have immersive experiences and digital experiences, which is something we'll go into later in this presentation. You can tell stories in a more innovative way than you might do in a brick and mortar store or through a news article. So you're really able to get into customers' homes, and if they're on a headset or in their laptop, they're able to have direct access to the brand. And then also just finally wider sales opportunities. So the case study that I'm going to be looking at is co-branding in the luxury branding worlds and the virtual world. So there was actually an announcement about this yesterday that LVMH and Epic Games are collaborating to create a virtual experience. So that is a play by LVMH to try and draw in customers with fitting rooms and fashion shows in the virtual worlds. And it's really not a new thing now. So in 2019, Louis Vuitton and the creative director of Louis Vuitton entered into a partnership with Riot Games, and they are the developers of the League of Legends video game. And those kind of partnerships can be really beneficial, but there are quite a lot of IP considerations that one would need to have a look at beforehand. So to enter into that kind of relationship, both brands need to collaborate by licensing their IP assets. So that might be trademarks, copyright, or design rights from one party to the other for commercial use. And in terms of protecting brands need to give really careful consideration from the very beginning as to how those assets will actually be used in the context of the partnership. So just a couple of headline points on the slides. Existing IP, you want to ensure that those licensing agreements contain appropriate ring fencing to provide protection over title, rights and interest, and existing IP. So a really good example for that is the recent Balenciaga and Fortnite collaboration. They had an existing Balenciaga trademark that they used in Fortnite, but they didn't necessarily create a new trademark for that purpose. They used their existing brand that had built up goodwill. You then need to think about the scope of the license. So for one party to use another party's IP rights lawfully, you need a valid and legally binding IP license in place. So you would need to ensure that the scope of the license, like the IP being licensed, the field of use, exclusivity, territory, and the term of use is clearly outlined from the outset. And rights holders also really need to consider whether the IP will only be used within that virtual partnership or also in the physical world. So again, to draw on the Fortnite example, the co-branded merchandise was available both online through the metaverse store and also in the physical world. And it's really important to make that distinction from the beginning in terms of registration of the mark. Finally, for games, you need to consider user-generated content. So certain collaborations might involve users creating things like skins or outfits. In the Balenciaga and Fortnite collaboration, users could submit images of their characters wearing Balenciaga clothing, and that would then be shown on virtual billboards in the Fortnite town square. So to avoid IP infringement claims from users, for instance, if I designed something and it was then used in an advert and I said, oh, that's my IP, Fortnite developers avoided this by explicitly stating in the terms of service for play that all users granted Epic Games the right to publish and display user contributions throughout the world in any media. So that again was a very clever play by them to generate all of this user-generated content essentially for free, and if anything, being paid for it because they're gaining profit from those who are playing the games. So generally, although we're seeing a lot of these popping up, to protect brand, rights holders need to really be cautious when entering into these partnerships and co-branding arrangements. And that comes from very beginning, even thinking, is this even the right kind of brand that we should be collaborating with? So it's really important for parties to diligence each other and reduce the risk of adverse reputational damage that the collaboration might have on their respective brands. And there's a huge increase. One was announced yesterday. It's likely that we'll see more collaborations soon between luxury brands and the metaverse as they try to reach new audiences and different markets. So that is the first case study of how fashion brands have really used the metaverse as a tool. The second one is virtual fashion events in the metaverse. So during the COVID pandemic, participation in virtual fashion events became necessary because people obviously couldn't see each other, people couldn't hire out event spaces or go anywhere. But the trend has continued post-COVID. So in 2022, Carly Kloss, the supermodel, launched a virtual runway on Roblox, and she had 5 digital pop-up stores to promote her virtual clothing. And Ralph Lauren also debuted a digital fashion line on Roblox in 2021. Many of you will have seen last year was the first ever Metaverse Fashion Week, and this year was the second one, which had a lot lower attendance than the first one, interestingly, which we'll come on to. But that idea of brands exhibiting wares on a virtual fashion week raises a lot of really interesting IP issues. So the first one is just general IP and cyber considerations in the metaverse. So in terms of IP ownership in the UK and EU, designers operating in the fashion industry can rely on design rights, which allow designers to protect unique clothing and accessories. But there's still ongoing discussion as to how those rights will transfer to the virtual world. Obviously, in the real world, designers can apply for registered design rights. They last up to 25 years. and you have unregistered design rights that can last for 3 years. So the vast majority of designs relate to physical goods, and although computer programs in the metaverse aren't products under the UK and EU legislation, it's well recognized at this point that digital designs for items such as computer icons and screen displays and video game characters would be protected by design rights, and digital versions of physical garments, we think at the moment, could be protected as designs. But again, this isn't something that's been hugely tested. So one issue that did come up during Metaverse Fashion Week was the fact that if you have a designer who spent ages in an atelier creating something, lots of people said that the 3D version had to dramatically simplify the aesthetic to translate it into the metaverse world. So that simplification of the design could lead to a different overall impression to what the designer initially intended, which could make it more difficult to enforce any design rights, even if it was originally based on a particular design. So it raises the question of, if you have a design house that spent a certain amount of time designing a good, and then that's transferred into the metaverse, if I was a software developer that had spent time writing the software to create that item in the metaverse, is the question of whether the software developer would also own some of the rights to that image, because that would then be distinct to the original product. So brands need to be really careful when working with designers and software developers and IT engineers to make sure that all of the rights are assigned back to the brand, and not just assuming that the rights will be automatically held by the brand. So trademarks obviously act as an indicator to consumers in the real world that a product or a service originates from a particular source. In the fashion industry, those tend to be brand names and slogans, but obviously in the real world, trademarks apply to real world territories. The metaverse doesn't really belong in a territory, so it's much more difficult for brands to know where to register rights. So just a few case studies. In January 2021, Chanel applied for the Chanel wordmark in the France Intellectual Property Office for Class 9. That included virtual outfits and accessories. And last year, Prada applied for just Prada in classes 14 and 41 in the Benelux office. But what's difficult for brands is being able to prove use in each of those jurisdictions. So many brands at the moment are just casting the net as wide as possible and applying for where they feel like they might use them, or where they might sell goods pertaining to those rights, rather than where they feel like people might access that metaverse. And just an interesting one that came up this year, the trademark rules that apply at trademark offices in the real world also apply in the metaverse. So earlier this year, the EU IPO refused to register the Burberry pattern as a trademark for metaverse related goods because they said it had a lack of distinctive character. So that's a really interesting decision because it shows that in theory, the rules and principles that are applicable to trademarks virtually are the same as would be in real life, be it consumer perception and distinctiveness requirements. So another thing to consider is the fact that in Metaverse Fashion Week, the goods were modeled by virtual avatars. So I've just got a really quick clip showing you, if you've not heard of this digital fashion model called Shudo. If I'm able to play that. Oh, so I'm not able to play that, but this image is a virtual supermodel called Shudo, who has hundreds of thousands of followers. And she was used in a Pretty Little Thing campaign. And Pretty Little Thing also unveiled a separate virtual model and said that that bridged the gap between the metaverse and real life. So the reason that's an interesting IP issue is because it raises the issue of which party will own the IP rights to virtual models. Again, ultimately, they will have been designed by software designers, and how those rights should be protected and enforced. So if a computer-generated model is created by the software developer, but it's based on a model's measurements, who works at a modeling agency, who kind of between those parties would own it? Again, you'd need to have a really explicit assignment from the beginning. Individual virtual models, such as Lil Michaela or Shido in this image, they might generate recognition and goodwill amongst consumers. So that goodwill might be protectable via passing off to prevent third parties taking advantage of the image and reputation of a well-known virtual model, which might have been built up by a significant investment by either the brand or a company. So if one was a brand, you'd also need to ensure that CGI models don't have an excessive likeness or incorporate iconic elements of a real life celebrity. So in 2020, Selena Gomez sued the developer of the Clothes Forever styling game for $10 million for using her likeness without their permission. The outcome of the case wasn't published because it was settled in the end, but generally brands should try and avoid the negative public connotations of being named in those kind of litigations by just avoiding the use of CGI models that bear a recognizable likeness to real world public figures. And just finally, this year, Metaverse Fashion Week and last year generally remained free of cyber attacks, but generally Fashion Week is a popular avenue for protesters to crash the runway and make socio-political statements, including campaigns against things like animal fare or unethical business practices and low pay for garments workers. So brands can easily address those issues in real life by having an invite list or physical barriers at the event. But obviously protesters could adopt cyber protest tactics to try and disrupt a virtual fashion show. So to give the example of Decentraland, which hosted Metaverse Fashion Week, it's browser-based, it can be accessed on the internet, and at the moment, we're not aware of any specific vulnerabilities, but virtual fashion shows could easily be targets for hackers. One example in the fashion art world is the fact that Banksy in 2021 had a cyber attack on his website, which led to a collector paying over £300,000 for a counterfeit NFT. So this stuff is happening. So brands should be thinking now of making additional investment to make sure that there's appropriate cybersecurity policies and process to mitigate that risk of a cyber attack by virtual protesters. But despite those considerations, there's definitely, in the future, I think we'll see more of these events. I think we'll definitely see more hybrid events where we're kind of looking at a physical event that blends into the virtual, or you can buy something in the virtual and then get it in real life. And just last year, Gucci announced it started to accept more than 10 cryptocurrencies in its brick and mortar stores. And Miami Fashion Week has also announced a metaverse debut. So the benefits of the move to have a virtual option are clear, but these are just some considerations for brands to consider when co-branding and entering into virtual events from an IP perspective. Thank you all very much for listening so well. It's hard to get virtual cues when I can't see anyone, but please do pop up if any of you have any questions at all.
Thank you, Anna and Uche, for sharing your thoughts and IP experience and consideration in the metaverse. So we have enough time to have a Q&A session. So if you guys have any questions, oh, sorry. My phone just, answers, AI answers my phone, sorry. So if you have any questions to the speaker, please say who you are asking and tell us about what your question is. So I have some questions in my hands, but I would like to give you guys opportunity to ask. So do you guys have any questions to the speakers? Okay, so I'd like to ask both of you, do you think the Meta Birkin's case will change how brands interact with the metaverse and digital goods going forward?
Well, I think with the Meta Birkin's case, it was kind of a reminder to brands that if you don't do it, perhaps someone else will first. So I think one of the issues with Meta Birkins is that because Birkin wasn't already registered in the virtual world and being used in the virtual world, it was harder for them. Obviously, they were victorious in the end, but that definitely made things more difficult. So I think brands might take a more proactive stance from the beginning, rather than not engaging at all.
I would like to add that we have a different types of metaverse experience relating to fashion and luxury. And this is one part how brands can use metaverse. But speaking about, for example, first sale doctrine and StockX and Nike case, when StockX use not a Nike brand, but the visual, how, you know, the shoes, how sneakers looks like. So basically that could be another single, not only to register your trademark, but to consider, for example, metaverse and NFT as a type of your customer experience. For example, for try to convince them that your experience, your brand is more developed, more interesting, and have maybe different, let's say, gamification tools to make the experience much richer and better and interesting. And this is where we have not a metaverse, but a digital experience. So yes.
Okay. And I'd like to ask Anna about, is it, you show us the terms and conditions of that the thing, and is it possible that the terms and conditions and platforms self-regulations become legislations of 21st century?
I would say that maybe self-regulation might be a key for metaverse platforms and decentralization at the moment. But as we can see, these rules can't come from nowhere. They still use basic legislation rules from the countries, from the jurisdictions they come from, or they reside, for example. So I should say that terms and conditions and self-regulations cannot replace legislation, mostly because we can create something from the scratch, and legislation and rules and self-regulations, it's not something that we can create from the nowhere. And secondly, because metaverse, as I mentioned, it's not about decentralization, it's quite centralized, you know, a creature of centralized world. So that's why.
Okay. And Uche, do you have any thoughts on these questions?
So this is a big cop-out, but I feel like Anna really covered it really well
Okay.
there.
Okay, so I believe we've been through, I really interested in about the co-branding IP consideration on your Uche's presentations. And do you think that post-COVID brands will continue to use the metaverse, or do you think it was lockdown stopgap?
I think that's really interesting because this year there was lots of stats around Metaverse Fashion Week and the fact that the attendee list, I think, had halved in size compared to this time last year. So I definitely think people kind of have that desire to go to places and feel the clothes they're wearing and try things on and meet people. But I think lots of brands are now, as I mentioned at the end of my presentation, going for the phygital approach, which is when you can play a game, order something in the game, and then have it delivered to your house, or play a game and win an award. And then the award in the game is to go to an event in real life. So I think we'll see a lot more of that, which some would argue is more complex from an IP perspective, because as I mentioned, if you have someone winning a virtual item on screen that looks a certain way, and then they get delivered it in real life, it's impossible for it to look exactly the same. So I think we'll definitely see a lot more hybrid events going forward.
Yeah. Okay. And we have question here from Debbie. There is an obvious conversation ongoing about trademark classification and where virtual good fit in. What are your views? Fit them across the current availability classes or a new classification altogether? There are obviously pros and cons. It would be great to hear from brand owners' perspective and also practitioners' perspective. In what jurisdictions? Yeah.
But I think it can kind of be answered for both. I think sometimes the issue with this is that often the IP offices play catch up. I can see someone mentioning the EU IPO guidelines, and recently in April this year, actually, the UK IPO released guidelines on NFT and metaverse goods and services. So I just say all you can do is kind of follow the guidance at the time. And I think the guidance at the time is for the specific best practice for NFTs and virtual tokens, whereas this time last year, it was about fitting the virtual goods in with the existing classifications. So I think it's definitely a thing where the offices kind of play catch up, and you just really need to engage with your local office. That's what we do at the moment, to see what's most appropriate at the time, because it's moving so quickly.
I can confirm that this is the best option you can do, because your IPO guidelines, no matter where you are, it's most important document for you and your local rules. And I do believe that maybe niche classification can develop in recent times, and that up some virtual goods or NFTs, because not all virtual goods are NFTs, and not NFTs could be treated as a virtual goods. But anyway, I do believe that the proposed way by Uche is the best one. I can confirm that we do the same.
Yeah, and in Korea as well, last year, the Korean intellectual property law issued the guideline about the virtual goods. So now Korean KIPPO says that the virtual goods and physicals are different. So, and we before filed the downloadable virtual goods program, a computer program. That was before the name of the virtual good. But now we don't need to do the wordy descriptions. We can just put the virtual plus name of goods. And the KIPPO says that the physical goods and virtual goods are different, but as Anna says that there's probably issue on the famous trademarks side, and it covers all the goods and services. So yeah. So I think that it's important to follow the jurisdiction's guidelines. Yeah. And any other questions you guys have? Oh yeah, in what? Ahmed Jara asked as we know that physical counterfeit goods are being recycled and destroyed, my question is what happens in case of virtual goods? Sorry, it's covered. And in case of Hermes, and do you think that user and buyer are responsible for using and dealing with it?
So I think, and I welcome your thoughts also, but the thing with the Meta Birkins case, which I think you're referring to here, is in people holding out virtual goods as having the origin of a certain brand. So the purpose of an NFT is that you're supposed to be able to see the provenance. It's meant to be non-transferable. It's very clear who's registered it. So if someone had dug deeper with these NFTs, they never actually said that they were from Hermes. It was just the kind of circumstantial evidence around them that suggested that. So I think it's really tricky in the virtual world to lie about where something's come from, because if you then go on the Hermes website and you can't see anything about it, it's an indication that it doesn't exist. But I think because of the difference in the way that we use virtual goods, it's, some would argue, less of a risk, because I can't really carry around an artificial Hermes handbag. So I think it's for users and buyers to be vigilant, because if you do your research online, you should be able to distinguish whether, I think it's harder to be fooled with a virtual item than a physical item. But I'm not fully sure what you mean by whether users and buyers are responsible, but I suppose with an NFT, there's, I think, on OpenSea and the different marketplaces that you buy them on, you can always kind of track the provenance. So that's always a way of making sure that you're not dealing with counterfeit goods in that sense. Not fully sure if that answers your question, but I welcome thoughts from Anna also.
I do believe that we have to distinguish virtual goods and NFTs, because virtual goods itself can be delisted from the platform. We can actually do something with them, because it's not necessarily associated with NFTs, not necessarily decentralized or immutable, because NFTs are mutable. It means that I as an owner can destroy it. Not destroy it, actually. I can send it on, to dead end crypto wallet. That's it. It's not destroyable. It's immutable. Just, no future for this token. But anyway, it's not destroyed as counterfeit good. So speaking about virtual objects, there are some possibilities that we can do something with them. So delist it, for example, from marketplace, from virtual space. But speaking about Meta Birkin and Mason Rothschild's NFT collections, there is something difficult with this collection, because at the moment, collectors, the persons who buy it, they basically, I do believe they don't want to destroy it, don't want to send it to data and crypto wallet. And OpenSea as a marketplace can do nothing with it. Anyway, they can delist it and they can ban the possible transactions of these, these collection, because they try to prevent further infringement. But anyway, they can do nothing with this token. And I do believe that buyers are not responsible. As Ucha said, you can check the provenance, you can check from whom this token, created or sent by whom. There is another case, Bored Ape Yacht Club and RRBC collection, and this collection little bit trickier than Mason Rothschild one, because Mason Rothschild didn't tell anyone that these are Hermes, this is real Hermes, but this is NFT back. But Mason Rothschild, in RIP's case, try to convince people that they sell the same collection, same NFTs. So we have to check the difference. And as we can see, metaverse NFTs is all about careful consideration with which and with whom you work with. So I hope we answer your question, because it's really very difficult.
Thank you. Oh, yeah, he answered that. Thank you for the clear answers. So I think our time is almost up, I think. So our session is finished now, and we have a quick break until 5 p.m. If you have more questions, please attend the AIPPI Cafe. Starts at 5, and we can continue our conversation there. So thank you and see you soon. I think, Samantha, are you going to hand over this conversation?
Yes,
Thank you,
we will.
Jaewon.
Oh, yeah, here we go.
Go ahead, Debbie.
Oh, no, not at all. Just going to say that, everyone can take a quick break, and we'll just be back in 3 minutes.
3 minutes.
Thank you.